Good morning, good afternoon. Everybody ready to go?
Yes, my lord.
Yes, thank you.
All right, Mr. Strange.
My lord, in terms of the brief housekeeping that we flagged up, I think what I'm going to do is just describe the issues to you and how we would like to deal with them, rather than having a full-blown debate now. I think both issues are unlikely to be resolved with the course of time over these submissions. Both relate to issues arising from evidence that two witnesses gave. I'll start with the most significant. You may recall that Mr. Brand, in his report as regard to hotels, did not set forth his 5-hotel sample size, and he divulged during the course of his examination. Having divulged the 5 hotels that he used, our experts went back to the source data STR to double check, as they would have if that information had been revealed in his report. They were given information by STR that would suggest that either Mr. Brand's approach was wrong, or indeed may not have even been obtained from STR data. So that's been articulated to the DIFC in email correspondence and clarification sought, and we've been politely told to buzz off. So that's issue 1. Issue 2 is probably less significant, but not to be ignored, and that just relates to Ms. Calaresi's qualifications. In her witness statement, you may recall, she said, "I'm a qualified lawyer," and then referred to 2 English law qualifications. I certainly got the impression that she was an English lawyer. She told us during her evidence that she wasn't, and she was a UAE lawyer, but she didn't need anything else other than to be a UAE national. We've checked the register, and we've checked the requirements, and there seems to be a discord. And we've asked for clarification, been politely told to mind our own business. My view is that this case will not swing on Ms. Calaresi's credit. If my personal view is wrong, and during the course of these submissions there's a great deal of focus on her evidence on a key point, I may wish to push that point further. On the Mr. Brand point, Mr. Williams, during his submissions to you on quantum, will make submissions about the hotels and the split. If great force is placed by the DIFC on Mr. Brand's split, and that becomes a contentious issue, we may need to make a formal application to either introduce the email that we've sent or the underlying STR views. And on the email that we sent, I mean, it is inter partes. We do think we can rely upon it, but given that there's been an objection to it, we're not going to put it before you at this point. So having outlined and indicated what the nub of it is and how we'd like to deal with it, I for my part don't intend to say any more about it, and we won't seek to put that before you unless there's developments that suggest that we need to.
Well,
You want to say anything, Mr. Montague-Smith, or not?
well, may I just say briefly, I mean, my learned friend has said he's not going to try to introduce the evidence, but he's just told you what's in it. So just can I just briefly explain to you why I say none of this matters? And I know there's no application to introduce it, but given that it's been opened in the way it has, if you just give me a minute to do that, then I can explain why none of it matters. The STR sets for Mr. Brand's evidence, if you'll recall, go to the question of ADR, that is the average daily rate for the hotel. But you may recall that there are 2 different ADRs suggested by each expert, one for each time date, 2013 and 2018. And the issue only arises in relation to the 2013 data, because when it comes to 2018, actually Mr. Brand's figures are higher than Mr. Williamson's, albeit Mr. Brand takes into account a temporary effect of the pandemic. When it comes to 2013, though, you may recall from his cross-examination, Mr. Williamson accepted that if he was to take into account hindsight, he would have come out at the same place as Mr. Brand. So the issue really comes down to not where the experts got their data from, but can you apply hindsight? That's why this is a great big storm in the teacup. My learned friend wants to apply to introduce new evidence after trial. As you know, the Ladder-Marshall type approach applies. There we are. On Miss Calarace's qualifications, as I recall, she said she had a law degree from England. And if my learned friend wants to make submissions, she said that's all I need to practice in the UAE, but I don't recall her saying or suggesting that she was in private practice. In fact, she is in-house, working in-house in a company. I'm not really sure where that all goes in any event, and quite what my learned friend wishes to say turns on Miss Calarace's evidence in any event. So that's why we say there's really nothing in any of that.
Well, I'll wait to see how things develop, I think. Thank you.
My lord, I have nothing else from the claimant side other than to commence our closing.
Yes. Thank you.
You will see we have provided you with a document that is in some length. The purpose of that and the idea behind it is to make these submissions more streamlined and fluid. And unless there's a particular document or authority or issue that you would like us to go to in specific detail, it's to give you all of the references that we say are relevant to the particular issues. I therefore do not intend to use this document as a roadmap through all of the documents I'm going to show you. It's more to give you the details for deliberations if you require it.
Well, I assume as it's a speaking note, you're going to speak to it.
Exactly, I'm going to speak to it, but the main point of speaking to it is that when I say to you the position with respect to BUA in a nutshell is as ABC, and the reasons why are these 7 documents. You have the 7 documents, you have the references, you have the dates.
Okay.
Now, my lord, before I delve into the speaking note proper, I ought to lay out for you how we say this case ought to be approached in terms of dealing with the facts and making findings about the claimant's case. And on that score, we say the first period is obviously critical to the determination of the claims. And the reason for that is because that period from 2007 to 2009 does 2 things. It sets the tone for the parties' relationship. And you will have seen from the documents that we've provided and the number of contemporaneous documents that we went through during the course of the examination of the witnesses that we say that we were being filibustered, run around. There were extraordinary delays, unexplained delays, and unreasonable positions taken. So that's the tone. But the second thing it does is it maps out what we say are the early breaches by the DIFC of their best endeavors obligations and their good faith obligations with respect to the clause 3.1 requirements. But it also, on the flip side, and this is just as important, sets out the progress the parties had made with respect to those obligations. And we say leaves the project at the end of 2009, the beginning of 2010, poised. Indeed, we say that the more difficult aspects of the parties' dealings, that is, deciding the commercial points like BUA, mix of use, ironing out the issues on concept design, had for the most part been completed, and that really what was left were the more mechanical exercises of the SPA, the joint venture company, the transfer of the land, and that when you look at all of those things in the round, those latter points ought to be capable of being achieved far more easily than the other things. So that brings us to the second period, which is 2010 through to, say, September 2012. And that is also critical because we say that's when the ongoing breaches reached their apogee and culminated in the renunciation and the events post the renunciation. That, although it's just as critical, we say is much easier for you to consider. And that is really because of the paucity of evidence from the DIFC, both documentary and from witnesses, as to what was really going on at the DIFC with respect to those lingering aspects of performance that needed to be undertaken. And on that, we say there are two features that ought to loom large. The first is there is clearly a disconnect between the project technical team at the DIFC and the legal department, in that the project team is having communications with us and they're giving us reasons as to why things aren't moving forward. And the legal team don't seem to be alive to or communicating with the project team and are reaching their own views apparently in a vacuum. The second critical feature is the absence of Mr Al Najar, and I will come to the detail of that in a moment. But the simple fact is he is by far and away the most important fact witness in this case on that critical period, because he was there for the first period. He was heavily involved in all of the commercial negotiations that led to agreements on BUA and on mix of use. And he was involved in the concept design. He's there during the intervening periods, the freeze out and the stonewalling of 2010-11. And he's around in 2012, and he's around subsequently. And as I will show you with precision, if anybody was going to give you evidence about what was really going on then, it would be him. And there has clearly been a conscious decision for him not to give evidence, and we say that has consequences. My Lord, we then can turn to what follows those two periods from 2013 to 2018. And I say that has now become pretty straightforward, and it's straightforward for the following four reasons. All of the discussions between the parties during that period were clearly without prejudice, subject to the claimant's reservation of rights to terminate the JVA. The discussions that took place made some progress, and they came close at times, and various different proposals were put. But the ins and outs of those discussions, we say, are of very limited reference to the issues in this case. And the main reason for that is that, and this is the third point, we say it's the claimant never clearly and unequivocally affirmed the joint venture agreement as amended. And the DIFC knew this. And it cannot be said that they thought at any point in time we were just getting on with the joint venture agreement. Neither party can say that. And then the final point is the 18 October 2018 performance letter. We say it doesn't come anywhere near close to a withdrawal of the 12 June 2012 renunciation. And we'll go into the reasons for that, but we've already foreshadowed them. It had a number of technical faults, it had a number of practical faults. When you look at the contemporaneous evidence and the witness testimony, it was a tactic as part of the negotiations to put pressure on. So we say, although that period needs to be considered, it doesn't need to be considered in the granular forensic way the earlier periods need to be considered. What I want to do now, my Lord, is turn, just as a reminder, as we said we would in the speaking notes, of the obligations under the JVA. Because we've all looked at this document in some detail, but we've looked at it from various different angles. And the angle I now want to remind you of is the party's obligations. And the best place for that is probably J1. Now, my Lord, if you could start, please, on J2. Now, these recitals, as you recall, are terms of the agreement as per the language of the contract. And it's worthwhile reminding ourselves of the DIFC's role in this agreement. And as set forth in A, it says master developer. And so that means it's effectively a development company or a master developer that wants to pursue the development of a parcel of land. And if you look at C, the securing of inward international investment for the development of precincts is a primary objective of the master developer. So what they were doing here under this agreement was finding an international investor to develop this project. And then D really gives us the essence, we say, of the agreement. The parties desire by this agreement to provide the basis upon which a joint venture company shall be established and the project shall be undertaken. So when we look at best endeavors and we look at good faith and we look at what the parties ought to have been aiming at during the course of the passage of time that I'm going to take you through, that's really what they were aiming at. And it's important because in simple terms, this was to build a prestigious tower and to make money. And if you're both using best endeavors and good faith to that, and you're able to agree the essentials such as BUA, GFA, and mix of use, and all you really have to do is sign off on an SPA, incorporate the company, and transfer the land, you ask yourself rhetorically, should that be done by those two parties? And the answer should be yes, because they're both mutually benefiting. And you get further color from that if you please look at the definition of project on J4. And that definition of project, development, ownership, management, exploitation for profit, we say clearly prescribes what the parties should have in the back of their mind when they're dealing with each other on the various Clause 3.1 obligations. The project computations you're familiar with, and they're as per Schedule E, I'll come on to those in a moment, as is purchase price. The sale and purchase agreement is Schedule C, and again, when we look at Schedule C, it's important to look at the degree of prescription that's set forth in Schedule C. And this goes to the point that your Lordship has raised during the course of this trial as to whether there was sufficient certainty for you to judge the parties' compliance, and also whether things that are present in this agreement can later be changed or on the face being consistent with what's in here and that still be enforceable. 1.5 just confirms that the recitals and the schedules form part of the agreement. 2.1 is important, my lord, for two reasons. The first is that the agreement itself doesn't come into effect until an investor is found and the master developer has approved that investor. Now that has happened, obviously. That's why the agreement continued. The master developer approved, although it was a somewhat tortured process, we say, did approve Hexagon and has never sought to resile from that approval. In other words, it's not alleged as part of this case that the JVA is invalid because that condition precedent wasn't in fact met. And that we say is significant when we look at all of the noise that you hear about the claimant's abilities to pursue this project. Now, my lord, there's one other clause I want to show you that we haven't spent a great deal of time on, and that's in it's 3.1.52 on J7. And that speaks of the parties, as soon as possible after the JV company has been incorporated, the JV company shall resolve at a meeting of its shareholders and directors as appropriate to adopt the following. And there's two things: the provision of the shareholders agreement, but the plans, proposals, and computations attached hereto as Schedule E and F, as they may have been appropriately amended prior to such adoption. And we say, well, that what that means is that the parties accepted that in pursuing, using best endeavors and good faith to pursue the project as defined, that things would change as set out in Schedule E and F, because it was a property development and markets change and various other things change that impact those. And so something that was appropriately amended would be to reflect that reality. Lord, if we could go on, please. And if you look at Schedule C,
where was the business plan overview in Schedule A?
Well, my lord, that I'm going to come to that in a moment. Our view of it is that what you see after the project computation seems to be the business plan. Although it says Schedule E continues, it does look to us like that's actually Schedule F, because Schedule F is blank. And when you look at the contents of what follows the project computations, it does look like a business plan. And I will come on to a moment and give you some submissions on that. My lord, I'm not going to go through the entirety of Schedule C other than flag up 4 for you. The joint venture company will be required to construct the project on the project land in accordance with the computations as adopted by the JV company pursuant to clause 3.1.5.2. And that's just connecting the dots. The other thing we say about Schedule C that is important is you look at some of the detail that's here. For example, in 6, into contracts to third parties. You look at 7, license approvals, 8, temporary structures, 9, service charges and rights of way, 10, cooling plants. These are all very prescriptive things that the parties need to include, that they've pre-thought and ought to, we say, in the context of good faith and best endeavours, make it very straightforward exercise for the parties to enter into an SPA and articles of association with respect to the day-to-day running of the JV company. If we could please move on to J15, which is Schedule D. The shareholding of the joint venture company, as we know, has a flaw as to the DIFC's interest, but can be mutually agreed to vary. And as we know, that's what happened in the event of the suggestion of Mr. Barazzi for a return in the size of the GFA. What's also significant is if you look at 5, day-to-day management of the joint venture company. Again, that's clearly prescribed. The last point, and this is a well-trodden clause, but again, we ought to remind ourselves, clause 6, the capital requirements. Two fundamentals stayed from here, that the liquid finance was to come from Hexagon and that the master developer wasn't going to invest anything other than the project land. Those 2 points stayed. The shareholders agreement did, as set forth here, more fully enunciate the arrangements for the investment of the liquid finance and the timely availability of funds. The point that the JV company shan't borrow, either from the investor or for otherwise, arguably was varied by the parties in the shareholders agreement and was certainly discussed. But we said that doesn't mean 2 things. It doesn't mean that the parties didn't enter into a shareholders agreement as per Schedule D, or B, that they weren't able to agree these variations, particularly as the shareholders agreement sought to terminate this agreement and create the regime going forward. So we say it's certainly something that needs to be carefully considered, but it's not a situation where the parties fell out, and the only reason they didn't proceed with the project is because we wanted to mortgage the project land and the joint venture company to borrow, and they said no. That is not the reason this project did not go ahead. So in that sense, it's important for you to understand what happened, but in no way is it, we say, critical to the outcome of this case. Schedule E, the project computations, obviously the project capital and the purchase price were things that varied, and we will show you the history of that. And as did the BUA. My lord, you'll see at the bottom of that page, Schedule E continues. But then when you look at what the next page is, and this starts on J18, it's called a financial summary, and it's a Hexagon model. And then when you look at what it contains, it's all scenario assumptions. And we start with built up area. And that includes, at the bottom, soft costs, contingency costs, and cost per square foot. And then estimates this is halfway down page J19, as to the capex. Then on page J20, scenario descriptions and scenario specific inputs, sales versus renting. And then finally, scenario outputs and financials, including hopeful IRR. Well, Lord, we say that pretty clearly when you go to Schedule F and there's nothing and it says see over, is Schedule F. And the significance from our perspective is, did the parties in good faith and using best endeavors discuss those things? And we say they were discussed. It was not always in good faith or with best endeavors from the DIFC perspective up until December 2009. And certainly post December 2009 all the way through to September 2012, there were literally no endeavors, let alone best endeavors. And if you're not doing anything, then there is no good faith. So the points to draw from that, my lord, are that a great deal was prescribed in the joint venture agreement. My lord, I think you're familiar enough with the amended JV that I don't need to go to remind of the change to 3.2 and the language there. So I'll leave that. But when we look at the JVA as amended, is this a Walford and Miles basic agreement to agree or negotiate? No, it's significantly beyond that. And there is great prescription as to the process that's to be adopted. There is prescription as to the commercial issues that need to be addressed and incorporated into agreements. And whilst there is flexibility as to those, because it's best endeavors, a party saying we exercise endeavors and they were reasonable and were clearly our best, they have to show you that their failure had nothing to do with the exercise of their endeavors. Now, I agree that between 2007 and 2009, that is a full-on forensic exercise, and you need to look at a great deal of email traffic and positions and try and sift through it all and come to a view. It gets much simpler sort of the beginning of 2010 because whether it's we get frozen, whether we're stonewalled, whether it's because of changes in management or a change of heart, it doesn't really matter. They're simply not engaging with us. And that, we say, makes it much easier. And it's also made much easier by the fact that they don't present to us during that period, either contemporaneously or for the purposes of this case, an explanation. They don't say, we changed our mind and put this on freeze and rejected the BUA and the mix of use that we had painstakingly agreed because of the financial crisis or because there was a change in management. And those things that we had agreed were no longer appropriate. And even though we used our best efforts and endeavors, we couldn't reach agreement on that. Because during that time, there is simply radio silence from their side from the project team as to what was really going on. And there's no documents. You have no internal explanations either. So, my lord, what I would like to do now is just turn, please, to the law. And if we could take up the speaking note for that purpose. Now, my lord, we have put these in as a reminder of the principles. I don't intend to either take you to any of the authorities or dwell on them for any significant amount of time, because I regard them as A, well-established principles, and B, although there are some debates around the edges as to the law, I don't see your determination of this case turning on any of those differences between the parties. So could I start, please, on page 2 of the speaking note? And in the first 3 authorities, we get given some of the ingredients. Must do his best, not his second best. all that it reasonably could to enable, and some commercial sacrifice. There's an expansion of that in Grandex, and we see that on page 3. Although it's, and I say that there aren't really directly analogous cases for you, unfortunately, in any of the areas that we're looking at, whether it be best endeavors, good faith, or renunciation. So we are really just looking at principles. But what's important about Granadex is you'll see there his best endeavors to obtain any necessary permission to export, but were nevertheless unsuccessful. And then the reasons for this contrast may one day have to be explored, but it's important to note that whereas here the seller has tried to obtain permission to ship, he need do no more than prove that his efforts were reasonable. And that's why I say when you look at 2007 to 2009, we say we get there ultimately, but you have to look at the detail. Once we're past that, it's a much easier inquiry because they haven't even shown you what they tried to do. And you have us presenting proposals for moving forward the last remaining aspects of the party's obligations that haven't been performed and not getting answers. And you have reasons given to Hexagon, DIFC management changes, they're not sure, etc. But you don't have any rational explanation as to the commercial reasons why all of that hard work got thrown out the window. And the IBM case, the reason we've slotted that there is because bound to take all those steps in their power which are capable of producing the desired result. And that's why the definition of project is important. If you go to the next box, and then we've got the standard bank case, honesty, good faith, and genuineness. Genuineness, my lord, is an important feature, we say, because when you look at things like the mix of use and you look at things like the BUA GFA, we say it's clearly not genuine to apparently agree something and discuss it, then to renege on that or delay approval of it or filibuster, and then not present any proper explanation for that either at the time or subsequently for the purposes of this case. And without being flippant, you saw Mr. Barazzi give evidence and you heard what he had to say. Where it was decisions that he made or things that he thought was the case, he would describe them. But in other instances, he would say things like, oh, it was a lousy bureaucrat or somebody being a lousy bureaucrat. And we say that things like that cannot be best endeavors. And indeed, they can't be in good faith when they come on to good faith. And if you look at John Scott versus Liam Bond, you'll see there playing fair, coming clean, or putting one's cards face upwards on the table. And where you're dealing with best endeavors and good faith, it's quite all right for a party to say, we agreed BUA 2 years ago, or we agreed a mix of use 2 years ago. But right now, we don't think that's appropriate anymore. And here are our 5 reasons. And we need to rejig and recalibrate our arrangements for the purposes of pursuing this project. And you're welcome to persuade us otherwise, or you're welcome to compromise. Because when you're open and transparent and you put your cards on the table, it gives the other party an opportunity to respond and engage with you and come up with a compromise. And if you look at mix of use, we went from 88% down to 66% over a period of time. And that was because at that point, some cards up and some transparency. But once we get to 2011, 2012 in particular, that doesn't happen. We're simply told nothing, and we are essentially talking to ourselves as we make presentations with respect to concept designs and so on and so forth. That's why we say these features of the test are very important. So, my lord, you will be obviously familiar with your own judgment in Vitalio. There, we say, I mean, words like arbitrary, capricious, or irrational manner We say it is arbitrary and it is capricious and it is irrational when you owe best endeavours and good faith to get things done like an SPA and the incorporation of a company and the transfer of land, and you simply don't do anything and you don't explain anything, and then you internally decide of your own volition that the effluxion of time that has passed means that the contract's over, and you don't even discuss it with your counterparty who's busy away doing presentations for you, sending you memos and patiently waiting while the flux in your management settles down. Now, my lord, there was, I think it was described as sophistry, my suggestion that a lack of good faith wasn't necessarily bad faith. And I think here's the conclusion, that if you are in a situation where you're supposed to be doing something and you're being arbitrary or you're being irrational or you're being capricious, it doesn't necessarily mean you're acting in bad faith. It just means you're behaving both ways. So I still say there's sort of a three-tier approach. You're acting in good faith, you're not because you're being arbitrary or capricious, and then there's a further level that you're acting in out and out bad faith. And I say we don't need to get to that level. On the, going to page 6, on the agreement to agree authorities, the only one that we would direct your specific attention to, my lord, is Aston Management, a decision of Legate J as was. And the reason for that is threefold. First, it's clear here where a party has given an undertaking, has endeavoured to make such an agreement or use best endeavours, it's a question of fact which a court can perfectly well decide. And it's acknowledged that that may be difficult, but proving a breach of a contractual obligation is an everyday occurrence and not a reason to hold that there is no obligation. And you'll see here where the parties have adopted a test of reasonableness, or here it's best, not reasonable. It seems to me that they're deliberately inviting the court to make a value judgment which sets a limit to their freedom of action. And that's exactly what we're asking you to do. We're asking you to take a judgment, given where the parties got to on the more difficult aspects of performance by the end of December 2009. The DIFC really exercised best endeavours and good faith with respect to the SPA, the incorporation of the company, and the transfer of the land. Now, you may, as part of that inquiry, pose the obvious question, well, the SHA, the condition precedent hadn't been complied with, and as a matter of law, it didn't exist. My lord, this case has several examples of the parties being in a situation where either of them could take a legal position to say, this is over, because there's a technical non-compliance with a condition precedent. We need to go back to the drawing board. And that would be a fair observation. But the real question for you is this. Given that SHA, the commercial aspects of it, like the split in the shares, like the position in relation to the increased BUA GFA, because they had been agreed and the parties had reached a position that you could easily look at the project computations and the JVA as amended and say that's where they've got to as appropriate. So that's part one. Part two, where there is nothing up until the end of 2012 and beyond from the DIFC coming back and saying, yes, we agreed this in the SHA, and yes, you've suggested that the SHA should actually be with Hexagon, but we should adopt large charts of it. We now disagree because of time and because of the global financial crisis, and they need to be withdrawn. That can't be dismissed. So on a technical legal ground, it's right that the CP wasn't complied with, but in terms of the real rump of it, the real important aspects of that shareholders agreement, where the parties have got to on the project computations, that cannot be ignored, and we say has to be the status quo right up until renunciation, and indeed in the months beyond, because they haven't presented anything to suggest why those had changed or needed to be changed or why they rejected them. And we get some help from that, again, from asset management. If you look at the bottom half of the box on page 7 going over to page 8, we say the simple point there is that just because an obligation requires something to be done by a particular date and that date passes doesn't mean the obligation doesn't continue. you still need to inquire as to whether there is a breach, and we accept that and we don't shy away from it. But what it really means is that the passing of the time to do something doesn't, as it said there, absence performance is waived or the contract is terminated validly, doesn't extinguish or let the other party off. My Lord, there's only two other aspects of the law that I want to focus on. Affirmation on page 9.
Well, before you go there,
Yes.
what we have is a series of mutual obligations resting on the parties to do X, Y, and Z, including execute agreements. The question arises as to how an obligation to use best endeavours on both sides works in the context of trying to agree terms for the future, and how you can look outside the framework of the existing agreement in order to determine that. In other words, how can the court decide what appropriate percentages might be, what appropriate financing might be, in the absence of looking at the original agreement and its specific provision as to who provides the finance?
Yes. Well,
that's the fundamental problem I have with this case altogether.
Yes. Well, can I address it in this way, my Lord? I say, in theory, that could be a very tricky issue for a court to grapple with in a case involving any of these types of agreements. But here, it's more straightforward than first impressions suggest, for this reason. First, the things that are left open by the JVA's amended for the parties are actually quite narrow. That's the first thing, because of the level of prescription that I've shown you. Second, and this is the critical point, as a matter of fact, the parties got there. This is not a situation where in the material period up to the end of, say, 2012, you are faced with one of those dilemmas where you have to say to yourself, I'm being told by the DIFC that the commercial arrangements that had been painstakingly agreed up to the beginning of 2010 no longer worked and couldn't be pursued. You don't have that case from the DIFC for that period. They don't say to you, we couldn't do the 65 anymore because of X. We couldn't do this state of land. We couldn't do this financing arrangement that's set forth in the shareholders agreement for this reason. So you don't have to.
Well, I do, Mr. Springs. And what about Mr. Abdullah's evidence? The global financial crisis changed it all. He couldn't go ahead on the same basis, is effectively what he was telling me.
Yes, well, that is true to a degree, my lord, that there is reconciling. And bear in mind this, the global financial crisis actually fits in nicely when we look at the chronology of this case. Because if you, as you must, we say, accept that by 2010, 1st of January, the only outstanding thing for the parties to do was the SPA, the company, and the transfer of land. They have survived, they have got through the global financial crisis in the sense that it's happening while they are going through all of these commercial points.
No, Mr. Strange. On your cases you're putting in now, at least as I understand it, you're saying that the commercial aspects have been sorted out in the 2008 SHA. Ignore for the moment it's CHL, not Hexagon. You're telling me that's what the deal was. And the odd bits and pieces, the BUA and all the rest of it, get sorted out during the course of whenever it is. But by the time the financial crisis hits, the whole world has changed. And that, on the evidence, hit Dubai first, second quarter of 2009, something of that kind.
Yes, I accept that.
They are still in a different world, he told me.
You may be in a different world, my lord, but he's not, nowhere in the contemporaneous evidence, starting with the Hexagon side, do they suddenly in the first quarter of 2009 say, yikes, we've had these commercial arrangements in place under the SHA in relation to all of the things, BUA, mix, financing, split of shares. we can't do it anymore, we want to stop. To the contrary, the contemporaneous evidence is replete with examples of Hexagon pressing for performance of, and I'll call it those commercial terms and those indices. And they don't say at any point in time, actually, we now need to have a complete relook at all of this because the whole world has changed. To the contrary, they're pressing on. On the other side of the coin,
Mr. Strange, you have to deal in that context with the 2010 memorandum and the 2012 memorandum, which specifically asked for a complete rejigging of the structure of the arrangements with a hybrid between the AJVA on the one hand and the 2008 Shareholders Agreement on the other.
Oh yes, we certainly don't shy away from that. But again, those two memorandums, what they say is that their fundamental change between the SHA and those memorandums isn't forget the project share split, forget the BUA, forget the GFA, forget the mix of use, forget the financing arrangements. It's not about that. What it says is, and this is very fundamental, we should take some of the aspects of the SHA, but we think the better structure is we have Hexagon in. And we have Hexagon in as the shareholder in the joint venture company. That's really the essence of those memorandums. And the real reason for that is CHL was a creature imposed on Hexagon, according to Mr Al Najar, because the DIFC didn't want Hexagon as a Cayman company as the shareholder. They wanted something more local. There was no real incentive from the Hexagon side to have CHL interposed. And we say, in terms of ownership and direction and control, it really didn't make any difference because you had the same UBOs as the shareholders. So I don't shy away from those saying we need to update the SHA and it'll be a hybrid. But they're not saying that because commercially everything's changed because of the global financial crisis. Indeed, they are being more true to the JVA as a matter of structure. And what's more, my lord, they continue to say, you need to give us the project land. We need to give you the liquid finance. They continue that as well. And if it really was a situation, and this is why the absence of Mr Al Najar and any real internal documents of the DIFC is so important. If the situation really was, they got those two memos and they said, well, we had agreed all of this important commercial variables, project computations and so forth, Schedule E and F. We've gone to all this trouble to agree it, and they're now writing to us saying we need to update the SHA and it needs to be a hybrid. And we don't like all of the things that we agreed, and the world has changed. They would have internally discussed it. The DIFC, you've heard all of the evidence about what they did internally with important decisions like this. They would have considered it, and they would have gone back to us, and they would have said, yes, we agree the world has changed. We agree we need a new SHA. And by the way, we don't like 35% anymore, or the BUA or the GFA or the mix of use, or what we put in the financing agreement on finance. We want to change all of that. And we're going to exercise our best endeavors in good faith to achieve that. And here we are, we're being transparent and open with you about how we feel. And then the conversation takes place, and then the parties fail to reach agreement. If those were the facts, I would see the challenges, but that's not what happens. There is stone cold dead silence from them internally on that, and we are never even given the opportunity to engage with them on any of the commercial issues that may have changed as a result of the world changing following the global financial crisis. And what you see from us, my lord, throughout 2009 right up to December, you remember the classic, this is unhealthy for the parties. And that classic email, this is unhealthy for the parties, that was calling for the satisfaction of the condition precedents in the shareholders agreement. So Mr Al Najar and the team at Hexagon may have felt that the world had changed because of the crisis, but it wasn't putting them off pursuing to the hilt the commercial terms that were agreed. And if you conclude that that's the case, and that they got nothing from the DIFC, and there is no evidence from the DIFC other than the missing Al Najar, they never got the opportunity to engage with the DIFC on their views as to the world changing. The DRC didn't exercise best endeavors or good faith because they weren't transparent with us. They didn't discuss it with us. They didn't engage with us. They didn't give us an opportunity, like we'd done in the past, to compromise. And bear in mind, my lord, on the financing side of it, the evidence I say that establishes this. Yes, the SHA allowed the mortgaging of the land or the placing of security on the land in the JV company, but it was optional. There was also the option for them to continue to finance. And the evidence is very clear. Look at the 2012 performance of Tamiet and the essentially unchallenged evidence. In terms of Saudi Arabia and them doing well in Saudi Arabia, they were making a lot of money. They were able to pursue this project if they had to without finance. So yes, my lord, I accept, and I'd be mad not to, that the world did change very substantially with respect to the development of projects. But in terms of this case, where Hexagon was at on the commercial terms and its ability to pursue, there was no change brought about by those changes. And I'm afraid to say for the DIFC, they can't advance a case that those changes meant that A, they changed their mind about those commercial terms, that they formed a different view on the essentials of BUA, share split, so on and so forth, that they raised those with us as they would be obliged to under their contractual obligations, couldn't reach agreement with us, and therefore the project failed. They simply don't and can't advance a case to that effect. And what that means is when you get to 2012 and ask what I say is a rhetorical question, at that point in time, is there any, on the evidence, as at 2012, is there any evidence to suggest to you that the DIFC had advanced an alternative commercial scenario reflecting the change in circumstances from the crisis and their new management to us? And sorry, chaps, all's changed. Have a look at this. No, that's simply not available. And if that's not available, two things follow. One, we had done our best, but they haven't. Two, that's really where our primary breaches occur and are sued upon. And that is by many months, 5 or 6 months post the statute of limitation period in which is the first week of April 2012. And my lord, you, in going through all of that, yes, there has been a huge focus on 2007 to 2009, but that's because that is really the forensically challenging period. And it is also, it's really where the tone is set. And in my submission, Hexagon could not advance the case it advances with respect to the breaches in 2012 without establishing that they had used their own best endeavors in good faith in the lead up to that. And what's more, that the die was essentially cast on the essential terms. My lord, I'm sure this is an issue that will get more airtime both during the conclusion of my submissions and Mr. Montague-Smith's and any replies. So unless I can help you further on that point at the moment, I will just go back to the legal principles. So on affirmation, my lord, I note that in the first instance in the Singapore International Commercial Court, as recently upheld by the Court of Appeal, you've gone through the principles with respect to affirmation, and in particular, Sotiana and Yukon. And my lord, I can't put it any higher than Mr. Justice Morbeck, as was put in Yukon in the box that we've put there, and then Lord Justice Ricks in Force India in the third box. And it's always odious, I say, to draw analogies between the facts of particular cases, but in terms of principles, I say it is a principle that where you've got a complex and medium-term relationship, and it legitimately takes time for the consequences to become clearer and the innocent party to consider its position, then the middle ground can exist, coexist with negotiations to reach a settlement. And we say it's clear that, like Force India, the DIFC knew or must have known that what we were doing throughout that time was without prejudice negotiations, and that we were not giving up our rights to sue them. And if you look at the later board minutes from the DIFC, they acknowledge that if no agreement is reached, there will be a court case, and there are risks for them. So I'm not saying that that's dispositive of it, but in terms of did they really think there'd been any affirmation? But in light of the arguments that are advanced and the view at the time clearly was not. Well, in terms of the gateway to damages, I will leave that to Mr. Williams to cover in his submissions. On 12, though, we've put some principles relating to adverse inference. In the first judgment, Justice Cockrell made the point that it's to be deprecated that nearly every party to every commercial dispute says there ought to be adverse inferences, and it's more nuanced than that, and it needs to be more precise. And in Magdiev, in subparagraph 2, you'll see there, we need to show you the point on which the inference is sought, the reasons why it is said that the missing witness would have material evidence to give, and whether the party asking for the inference has adduced any of their own relevant evidence. Now, in this case, we say we're able to do that, and if you could, go, my lord, on to page 13 of the speaking note, really fundamentally relates to Mr. Al Najar. And you'll see there, he at material times held critical positions at the DIFC. And when you look at the issue, my lord, that you and I have just been discussing, did the world change and that have an impact upon where the parties had got to commercially? If there was ever anybody who could articulate that to you, it would be the director of projects at the DIFC, and the man who had negotiated throughout things like BUA and mix of use, and was engaged with things like the concept design. And I say it's simply not open to the DIFC to advance a case based on the GFC or commercial grounds inconsistent with what was reached in the SHA without calling Mr. Najar. And the reason for that is, I'll come on to a moment, the specifics of his involvement. But on the PTR, he was nominated as a witness. Mr. Visser was very clear as to why he wasn't. He said the solicitors made a decision that he wouldn't. My lord, you have been around enough, both as a trial lawyer and a judge, to know why a legal team decide not to call a witness, particularly a witness that on the face of it is very important. It's because they're not particularly enthusiastic about what that witness has to say. And I make no bones about it. We say that on the issues that I'm going to show you, you should draw the inference that Mr. Najar did not have evidence that would help the DIFC's position. And in 4, this is on page 14, we have listed the specific topics. So Perkins and Will, my lord, that we say was clearly a DIFC decision to impose them upon the project. They were a competition winner. You've seen the appointment letter and the organizational chart. And you have also seen the communications with Perkins and Will when there was a consultant brought in to review their work and the question of efficiency, and the mutual decision reached between the DIFC and Hexagon to terminate Perkins and Will because they couldn't get to 80% efficiency. So he's Mr. DIFC on those issues. the project mix, there were a number of parties involved from the DIFC, as I'll show you in a moment, when it came down to finally agreeing it, but also we say, not good faith and not best endeavors, waxing and waning on that, and the blunt letters coming back saying, despite the agreement, the master plan applies. That was Mr. Al Najar. The affection plan and the apparent delays between that being procured and signed off, that was Mr. Al Najar. And he was also involved at various important points in the BUA GFA. And if you look at 4.5, my lord, this is, again, a very important piece of the puzzle on the issue that we have been discussing. He was present from 2010 to 2012 when the project was frozen, but we hear nothing from the DIFC with respect to, we don't like the commercial arrangements anymore. And the project manager for the DIFC is the man to have been saying, look at the global financial crisis, look what we've agreed, this ought to change. My lord, if you look at 7, there are just 2 internal communications from Mr. Al Najar. And given his predominant role in the project and the issues that I've just flagged up for you, that is extraordinary. My lord, on page 17, we have the chronology of his involvement. And this is the detail behind what's in 4.4 as to the issues that he's involved in. I would like to, for the purposes of today, just flag up on page 23, 24th of June, F191 or page 1524. He's the one that sends the memo to the government.
Wait a minute, Mr. Strange. I'm just looking at pages 17 onwards.
Yes, sorry, my apologies.
You're all right, I'll go through those later. Yeah.
Yes. My lord, if you look at the 24th of June 2009, Mr. Al Najar sends a memo to the DIFC governor seeking approval for the revised GFA, approval of the mix, and approval of the plot details. If that's the position that's taken in June 2009 in an internal memo that he is the author of, and we have the December 2009, where are we on completing the condition precedents in the shareholders agreement? Having been the proponent of what was finally agreed with Hexagon, the person who could explain if there was a change, and bear in mind, this is the summer of 2009, the global financial crisis is more than a year old globally. It certainly hit the DIFC. It's here, it's arrived. But those essential commercial terms have been recommended to the governor by Mr. Al Najar. If he, in the months that followed and into the next 2 years, of his own volition or with others in the DIFC, resolved from that view because of changes, if the DIFC was to be acting in accordance with its obligations, best endeavors and good faith, I don't say that they could ignore those factors. Indeed, I say that when you look at best endeavors, you actually have to look at what's happening in the market. If you're, for example, the Atlas decision I've shown you, that was about securing a financing arrangement. If interest rates go up significantly during the period of time that you're supposed to be negotiating a financing arrangement, of course, if you're exercising best endeavors and you have to make some commercial sacrifice, you have to accept that the interest rates may be higher. And if that wasn't contemplated in the underlying agreement, you ignore it. Yeah, I accept that the DIFC certainly could have come back and said, things have changed, we need to change this. But then you would have to have some evidence to that. And you would have to be satisfied on that evidence that they did exercise best endeavors and they still failed, and that was reasonable of them. But you don't get into that because there's no evidence and no endeavors and nothing ever presented from their side during the critical period. And my Lord, just to close it at the end of on the 4th of March 2014, Mr Al Najar was present at a DIFC meeting. So that just closes the loop in terms of his involvement in the times that we're aware of and we've got evidence, and later. My Lord, the next section, page 24, the failure to produce key documents. Quite simply, my Lord, and I don't suggest that just the numbers tells the full story. You need to look at it more closely than that. But it is, I would say, incredible that when you look at the outfit that we are, which is essentially 3 high net worth individuals owning a Cayman company, and we produce nearly triple the number of documents that they produce, and only 50 relate to the critical period, that is telling you something. And only 10 of those are things we didn't have before, and only 2 are internal documents belonging to the key witness. And there's only 5, this is paragraph 5, and there's only 5 documents during the really critical freeze period, and none of them are internal. That does start to tell you a very important story. Now, I know what will be said. There's a document production order, and we're not in the world of every document known to the parties being produced, and I accept that. I don't suggest, this isn't me saying they're in contempt because they've breached an order. But what disclosure under the DIFC rules says is you must disclose any documents you rely upon. And if you were going to argue that you exercise best endeavors in 10, 11, and 12, or that you changed your mind on the commercial features that the parties got to, or there was a very good reason why you couldn't, as was impressed upon you in December 2009, just get on with the SPA and so on and so forth, then you ought to produce the documents that clearly seem to exist based upon the evidence. And if you don't, there are consequences. Now, my Lord, in what we've done in the missing documents in the detail is gone to the various periods, referred to the witness evidence as to whether documents exist. And that, we say, is when you are looking at any feature of the evidence and deciding whether there should be an inference of an adverse nature drawn. You clearly have our position on what's missing. And I'll give you an example. If you look at page 3 on page 26, we say it beggars belief that the decision to increase the project BUA in return for an increase in the shareholding, and therefore to change the project computations, wouldn't have been subject to some pretty detailed consideration within the DIFC. And we say there that Mr. Barazzi's evidence in that is pretty important. Now, that when you then look, well, how does that help me with respect to the issues I've got to decide in this case? One of the things the DIFC argues is, Hexagon chucked out the joint venture agreement and pursued an entirely different arrangement. That's one of their points. We say that's wrong. What happened post the JVA between the parties clearly was under the JVA. But the big significant change in relation to shareholding and therefore the BUA GFA, it appears to have been Mr. Barazzi's idea, and he was quite proud of it. It seemed to me he thought he'd done the DIFC a real solid, had got something that was of real commercial benefit. That ought to have been discussed internally and presented. That's one aspect of its relevance. The other is if there was a change in heart and they changed their mind later in 11 or 12 because of market conditions, you would expect them to look at this earlier rationale, explain why it had changed, and explain why they were going to come to us with something new. 4 is also important, my lord, in the sense that there's been cross-examination of Hexagon's witnesses about whether they really did have the wherewithal. But the condition precedent was satisfied. Hexagon was approved. There were some money laundering issues that were raised 3 times and done with. The IFC spent, the better part of 12 years talking to us about doing a project. Don't you think it would be interesting to see what they internally actually thought about our finances and our ability to pursue this, and see whether that argument has got any real steam?
What requests did you make for production of documents that you say haven't been observed?
Well, my lord, for the pre-2012 period, we made a number of requests, but your lordship ruled that pre-2012 documents, apart from the odd exception, were not required from the parties. What I rely upon here is less about, as I said a moment ago, I'm not saying that you should, they're to be chastised for not complying with the document production order. It's something different from that. It's if you're going to advance a case where critical issues as to your best endeavours, where it's alleged you're in breach of your best endeavours obligation, and you have documents in your possession for a critical period of time and you don't rely upon them, that is where you can draw your adverse inference. And it's separate from not producing documents in accordance with an order. It's you can voluntarily produce things that you rely upon. And the correspondence between the parties is clear. When we complained about a lack of particular documents, we were told we have produced documents that we rely upon. And if that's what you do, and there's something that's not there that could be relevant, it's your prerogative, but the consequences also rest on you. So what I'm essentially saying, my lord, is there doesn't have to be an extant production order for the absence of some documents to lead to an adverse inference. My lord, if you could look up, please, on page 29 at box 8. You have seen there, at the end of 2009, it's not healthy for the parties email, but you will have also seen the negotiations and the discussions that were passing between Mr. Mehta, the DIFC lawyer who was responsible for the articles, and then somebody from the DIFC registry that Mr. Barazzi identified on the incorporation of the company. So here, the only real explanation you have between that unhealthy for the parties email in 2009 and later points in time as to why nothing happened is the board minute that says, oh, due to the effluxion of time, the SPA, this agreement has been terminated. You still, as we sit here today, don't have an explanation by way of documents or from a witness as to why those steps didn't take place. And there could be a multitude of reasons, but there needs to be one proffered, and for you to decide whether that's reasonable, for that to be accepted. My lord, you and I had a discussion about the position on the 2010 memorandum. If you look at 10, box 10.
Yes.
There's nothing, we have nothing from the DIFC on contemporaneous views. Not Mr. Farouz, not Mr. Al Najar. We don't have any documents.
Well, my recollection, and I may be wrong about this, Mr. Strange, and you can show me otherwise, but even on the documents passing between the parties between 2010 and 2012 were absolutely minimal, weren't they?
Yes, you're right. You basically have two things. You have about 15 documents, which include the two memos, the three or four presentations, and some email traffic. You also have, my lord, the evidence of Mr. Al Najar, and on the project side, Mr. Al Fadl, in his witness statement, he's got a section relating to that period of time. It's paragraph 28 onwards of his witness statement. So page 11 to 14 of his first witness statement.
Yeah.
Mm.
Well, there's almost nothing there.
Yeah,
paragraph 31, nothing. I wrote alongside it, nothing happened in 2011.
Yes, yes.
And bizarre.
It is bizarre. It is bizarre, my lord. But we say bizarre and hugely problematic for the DIFC, given Hexagon's position. We'd gone through all of this trouble. We'd got there. We'd badgered you every day on everything, and it took us such a long time to get here. We've known a simple thing of just the companies transfer the land, let us get on with it, and radio silence. And yes, I have the burden to show that they've breached their obligation, but I say it gets much easier post that unhealthy for the parties message, because if it's best endeavors and good faith to pursue the project, and we've done the hard negotiation, you must show us a fair bit to say that, well, we did exercise best endeavors, it just didn't get us anywhere. My lord, I won't go through every one of the documents ones. I do say that 10, 11, and 12, box 10, 11, and 12 up to page 32 are very important. My lord, that's
boxes which?
Boxes 10, 11, and 12, which are on page 31 and 32. My lord, that may be a convenient moment for the transcriber, given the pace, which I will try and reduce after the break.
Are you getting notes telling you to slow down?
I'm not, but I suspect that's just because
they're polite.
It's polite, and it's a Monday morning. But it is anyway, my lord. Point, my lord. You will see. I'm about halfway through. Well, perhaps not quite halfway through. The next passages are passages that I will speak to, but more at a high level, because this is one area where I do think the party's evidence, examination of the witnesses, did traverse a great deal of this, and it's really the conclusions that I ask you to reach with respect to each point that count. So I won't speed up my voice, obviously, but I will speed up the pace to which I go through the documents, if that makes sense. So, Lord, I make it 20 past, back at half past.
Yes, very good. Thank you very much.
Thank you.
Yes, Mr. Strange.
My lord, by way of reminder, the significance of what I'm going to show you now on what I would call the project-specific points is threefold. First, we can't pursue a case that they're in breach if we did nothing. So we have to satisfy you that we were pursuing this project. Second, we say that particularly in 11 and 12, the DIFC was in breach because it didn't exercise best endeavors and good faith. You can't look at that period for what it is in terms of not much happening unless you know what had happened to that point in time and where the parties had got up to. In other words, your your factual inquiry to judge whether those obligations are being complied with has to be founded in the parties' relationship to that point in time. The third thing is, because your lordship is quite rightly, during the course of this trial, raised this question of was there sufficient certainty in the obligations to allow the court to make a judgment on compliance. The third relevance of all of this is where the parties have got to. Was this 1% performed, or was it 75% performed, or whatever? If you don't split it on percentages, had performance taken place already in relation to key aspects? This body of evidence is important on that score. So, my lord, if we could start at box 35, page 35. These are our high-level points with respect to the concept design. First, we say concept design cannot be relied upon by the DIFC as a reason that the project failed. And the second point that's very important is there was a great deal of work and effort put in by Hexagon to establish concept design. And like many parts of this case, it sort of falls into three categories. There's the Gensler, there's the Perkins, and then there's the CSI. Now, with respect to Gensler, the ultimate position is that the DIFC rejected Gensler on what I would describe as a bit of a whim. We've got secondhand evidence that it was felt that the design was too similar to another building, and so they were removed. Perkins and Will were very much brought on at the behest and at the drive of the DIFC. Both parties cooperated with respect to their design and where it was going to get to. And that design was ultimately rejected because of the efficiency issue that the parties were at one on. And what I say is that augurs well for the agreement on a concept design later, because it was one of the rare areas where the parties seemed to agree. They wanted something iconic but efficient. We then get to the CSI design, and that was presented to the DIFC. Work was undertaken in relation to the pursuit of it. It formed part of the presentations that we made in 2012. But we never got anything back from the DIFC to say it's horrible, we don't like it, or it's too similar, or we're worried about the efficiency. So that's the issue at large. My lord, if we could go down into the detail, and if you could start, please, on page 38. I think it's the fourth box down, 27th of June 2006. There is a presentation to the DIFC in respect to the Gensler design that seems to receive a positive response. And so we said there's nothing in the suggestion that, I'll put it this way, my lord, there was a lot of cross-examination about the Gensler design being a waste. I don't think, like in legal cases and in designs of buildings, if work is done on a proposition or proposal and it's ultimately discarded, doesn't mean it's a waste. It just means that was part of the journey to getting where the parties went. But certainly here, when you look at it, there was equilibrium on Gensler, who, of course, are well known in the DIFC, and you heard the evidence about the other projects they'd done. By the 11th of December, if you could go to the next page 39 and look at box 11 December, it's recorded secondhand in an email that the DIFC didn't like it because of the similarity to the Gargash Alderman building. Mr. Al Najar's evidence on that is that there was something more to it than just the design, and you have that evidence in the next on the sideline box. So we say that's relevant to you for history, but there's nothing as regards the ultimate determination of the case that you need to take from that. We then get to Perkins and Will, and as I've already submitted, and you may recall going through the Perkins and Will engagement letter and the chart, that was they were imposed upon us, and we didn't seem to feature. But we were certainly the ones that pushed Perkins and Will and the DIFC to get on with work. And you'll see, for example, if you look on page 41, third box down, 27 August 2007. I was chasing the DFC regarding the concept design and pressing because it's an important project. If you go to the second last box on that page, you have a proposal submitted by Perkins and Dewan for the project. And then, so you can assume that from that point, significant work is going on. If you go to the next page, this is page 42. In July, you have us paying the costs of both of those consultancies to get on with the work. And there's a meeting that follows where we make it very clear about the efficiency. That's on the 31st of August. The next day, there's a Hexagon DIFC meeting. And although there's nothing recorded on that day as to the agreement on 80%, subsequent events confirmed that that was the position. My Lord, if you go to page 43, it's on the 14th of October that Russell Van Diver comes in, and he is the one that raises, in quite blunt terms, the position with regards to the efficiency and Perkins and Will not getting there. That's then brought to Perkins and Will's attention. And those discussions gradually get more heated, and you see, if you go, please, to the next page, page 44, that's the final box there, page 27, there's a formal letter from Dr. Adele to them regarding the measure of efficiency and clarification of the details in respect of that. Mr. Van der Diver's report comes in December. We see that on page 45. And he's quite scathing about the efficiency that they've achieved. There is a rubber hit the road meeting, letter to PNW on that in December, mid-December. They come back to us on the 8th of January. That's the third last box, saying they think they can do 80%. But of course, in the event they fail, and then the wheels slowly come off the relationship with Perkins and Will denying that this has been an issue from the beginning, and TPM and, dare I say, the DIFC disagreeing with that. In February, you'll see this in the final box of page 46, the DIFC and Hexagon agree that there should be one last chance, Perkins and Will. That's not achieved in the month that follows. And then there's a joint agreement they ought to be terminated. And that happens in June 2009. So again, my Lord, if this case doesn't come down to whether the parties using their best endeavors could have agreed the concept design, but if that was the only issue, what I would say to you is that the parties are actually at one on that, in the sense that they're agreeing on the critical question of efficiency. And from this point on, all of the discussions are about a one tower block, not two tower block. And if it was going to be said that best endeavors were exercised by the DFC and they just didn't work on concept design, what you would need to see is in the context of the CSI design, which, as you recall, is a one tower block, and was referred to in both the February and April 2012 presentations, as well as one of the earlier ones. It's towards the end of both those presentations. It's a single hexagon tower. That was provided, and we see this on page 47, the second box. CSI presents its concept to the DIFC. The position, as we read the evidence, both contemporaneous and from the witnesses, is that the DIFC never came back on the CSI design. We continued, and we met with CSI in September. We got the JLL feasibility study in December. And then once we got the positive results from that, we started getting requests for proposal for consultancy services on the CSI design. You, as the evidence stands, you don't have anything from the DIFC as to the issue with that CSI design either way. And so as you sit back and look at all of the various commercial issues, for example, my lord, whether the global financial crisis changed the view on whether this design and this efficiency was appropriate or not, it can't be said that we hadn't used all of our endeavors in good faith to come up with a design, but unfortunately on the key one, the CSI one, we got stonewalled. My lord, we put in there for completeness the position on Larsen and the BEC group, just so you have them there. From our perspective, it's simply more of the same, us engaging on that issue of concept design. If you'll see on the 11th of March 2012, it's page 48, the second box. We provide to them the mix of use that the parties have agreed back in 2009, and we move forward on the same basis. So certainly well into 2012, as by the end of the third quarter, commercially we're on the same page when we're dealing with our concept designers. My lord, if I could now move on, please, to mix of use. And on page 50, there's three features of this that are important. The first is we accept that there was a lot of to and fro on this, and that when you look back in time at the early DIFC master plan and compare it to the most recent DIFC master plan, there's a significant change in mix. And we say that's not surprising given that market demand and conditions change. But that doesn't render two things. One, a lack of certainty in terms of enforceability on mixed use, because the parties in the event were able to agree that. Second of all, just because we moved away from the DIFC master plan doesn't mean there was any kind of breach or lack of good faith on our part, or that them just relying on the master plan was good faith, because it's pretty clear from the evidence that that's a guide, it's always evolving, and what you really need to do, particularly when one of your endeavors is to produce a profitable project, you need to take things into consideration in terms of what's the best for the project. The second thing is we say it was at best shambolic, at worst not honest, disingenuous of the DIFC to treat us the way they did on mixed use. And I'll go into some detail on that in a moment. The third thing is that this use that we ultimately concluded is the mix of use that we say you ought to consider for the purposes of 2012, and whether, absent the parts of performance that hadn't taken place then, there was a certain commercial arrangement between the parties that could be pursued. And we say on that mix, the mix that was agreed in by the end of 2009 was certainly commercially appropriate at the time of the critical breaches.
Why do you say that would be appropriate in 2012? I don't think I've got any evidence as to what would be an appropriate mixed use in 2012 at all, have I?
Well,
you know, life has changed. There's no question about that. Everybody says that about the DIFC. We know from later discussions, of course, by the time you get to 2018, but that's 6 years later. But what about 2012?
Well, my lord, you're right. You don't have anything from the DIFC in 2012 saying that, I'll call it the 66% mix, because that's the one. Yeah. You've got nothing in 2012 from them saying that's no longer any good to us. It's wrong. It needs to be varied. You've got nothing from us saying we resolve from the 66% mix because we don't like it anymore. So that's the starting point. What you do have from the summer of 2009 till the end of 2009 is the parties formally endorsing the 66% and us pursuing it. And for example, in December 2009, when we get a feasibility study from JLL, we rely on the 66% mix. And JLL note in that, as you will recall, that the rents have gone down by 25-30%, office and residential, and that everybody's suffering. So there is plenty of contemporaneous evidence to say the 66% was established during the course of the impact, and at the end of the impact and well past it, there was no move to change it. When we got our feasibility study, independent feasibility study, and relied upon that mix, despite all of the fallout from the GFC, it was still a viable, feasible project, and we went ahead. And then in the communications that we do have in 11 and 12, you don't see us saying we'll have to completely redo the mix because of the crisis. And the reason I would advance, my lord, is because if JLL tell us in 2009, post-crisis, post the specifics of the impact, this is still viable at this mix, that's pretty powerful commercial evidence. My lord, if you want those references or want me to bring them up specifically now, I can. The JL report starts at 1577. I believe that's bundle 3. And my lord, if you kindly just look at, do you want the internal page numbers or the pagination?
I don't mind.
Page 5, internal, executive summary, introduction, DRC Tower, approved mix of this development offers 66%, and then there's an alternative mix under consideration. And then right-hand side, is the project feasible, is the first bullet. And you'll see the third bullet, should the tower feature a higher proportion of residential or office? So that's the brief, if you will, my lord. And then if you look at page 6, commentary, lease prices for office space, sales prices, average daily rates, all of them have come down between 2008 and 2009 in the DIFC. So we were still presenting the agreed mix to a market expert who were telling us that everything was down because of the, okay, it doesn't say there because of the GIFC, but I think that's a fair conclusion. And now, my lord, if still,
can you just remind me as to where you say this was sent, when this was sent to DIFCA?
It's dated December 15 December 2009.
Well, I know
I'll have to. I can't tell you off the top of my head of when it was shared. But Mr. Caspian,
my recollection is that it wasn't, but I may be wrong about that.
No,
this is a draft, isn't it? It says draft final report. So presumably there was a final report at some stage.
Presumably, my lord, but in terms of the evidence, the only thing I have seen myself is internal considerations within Hexagon of this. Mr. Healer, who's has an encyclopedic knowledge of these documents, will double check that I'm right on that. But I have not seen an email sending this to the DIFC. What I have seen is in the presentations that were given later the sort of colourful PowerPoint ones, there is a reference to a feasibility study. Yeah,
I remember that, but I think it's the DIFCI's case that they never received either another concept design following the rejection of Perkin and Will, nor a feasibility study or a business plan. But I may be wrong about that, but that's my recollection.
That is their case. I think they're wrong on the first one, and I've given you the reference for where we say they got the CSI design.
Well, we get a picture.
Yeah.
But I haven't personally. I haven't seen anything other than the picture. But that may be just that someone hasn't taken me to it.
Yes, I will come back to that then in a moment. But in terms of this, my lord, the complaints about not receiving these documents are very much after the event. Their lawyer arguments, looking at things and saying, "Oh, you didn't do this and you didn't do that."
Yeah.
Certainly at the time, if we're there making presentations referring, remember they were in-person presentations.
Yeah.
If we're making PowerPoint and saying, here's the concept design, we've done a feasibility study, it's still feasible, et cetera, et cetera, et cetera. If that was really a genuine complaint at the time and really a concern, a master developer will say, thanks for the flashy presentation, but where's X, Y, and Z? And we're not considering moving forward until you've shared all of this with us. So I say, from that perspective, they're bad points for the DIC to raise. In terms of this evidence, what I say to you, you posed the quite right question. What's my evidence that this mix was applicable in 2012, given the crisis? And I say this is very good evidence of that, because here we've got the brief, which is 66%. We've got the impact of the crisis. I mean, let's be blunt about this. Property developers like to pretend their business is rocket science, but really lease sales and average daily rates, those are the three things that count for developers that we see on page 6. You're on mute, my lord.
Maybe a matter for Mr. Williamson, not Mr. Williams, I should say, rather than you. But you've done your damages calculations based on something entirely different for mixed use.
Yes, and that's why I was careful to say to you, my lord, that for the purposes of breach in 2012, say summer of 2012, you have, amongst a number of issues, you have to decide whether there was anything that would suggest to you that Best Endeavours wasn't going to get the parties there on some key feature of the agreement. We say they're in breach, they say they're not. You pose the question, one of the things I, as the presiding judge, need to deal with is, was there sufficient certainty given the nature of the JVA? And what I say to you is on that, on mixed use, you can be confident, and you can be confident to move that in the summer of 2012. Now that's the working assumption. You raise another good point, which is, well, that's fine, but what about the effect of the global financial crisis on that agreement, given that it was reached in 2009? And to that I say, here, from Hexagon's perspective, this feasibility study was that 66% mix. Page 6, the three really important requirements that are impacted by the GFC, are set forth there. And then if you go over the page to 8, you'll see they say we have examined the following two options. And option 1 is the 66% mix. And on the right-hand side, the project is feasible. Option 1 is financially more attractive than option 2. The hospitality component is to be excluded. office is performing better than residential. Costings seem to be at the upper end of the typical range. So, my lord, I accept that there isn't anything dated the summer of 2012, but I also say that there is no evidential reason why you can't rely upon the 66% mix as being GFC proofed and accepted by Hexagon and their independent advisors as a feasible way to pursue this development as at the summer of 2012. If the DIFC wanted to advance the suggestion that it wasn't, I would say it would be inconsistent with the evidence and their behaviour, but they simply can't say that to you other than a bare assertion from counsel because they have no evidence internally or from a witness on that. My lord, just on the design, the CSI design, it's Dr. Adele's evidence, graph 35, he talks about the presentation on the 27th of August 2009. And then the presentation that we've referred to is that's the 15th of February 2012 presentation. And you're right, it is a picture. And that footnote 37, my lord, is the is D109. Now, my lord, the only additional points I wanted to cover on the detail of the mixed use, if we could take up page 53, please. Spring 2008, that's where we have what we say is an agreement on the 88%. My lord, you heard the evidence and saw the explanation provided by Mr. Barazzi about whether an agreement was struck. My submission is that his answers weren't particularly compelling. He says, I can't tell whether there's an agreement unless I saw the percentages. I say it's highly unlikely. He's not a shrinking violet. He was quite a fiery, feisty character in my humble submission. If he got copied in an email saying an agreement had been struck, and he either didn't think an agreement had been struck, or he wasn't sure what agreement was being referred to, he would have made himself known very quickly, either by phone or by email, and we just don't have any of that. What that leads to, my lord, we say, is a pretty tortured process where we are trying to rely upon this agreement, and what happens is we get told, and the first example is on the last box on page 53, oh, no, it's back to the master plan. Then we write, we consider that to be a major backtrack. We write, And then Mr Al Najar, and this is 12th of August, so this is on page 54 now, on the box, third box down, sticks to the plot guidelines from the DIFC. He's again told that there was an agreement, and he's suggested he speak to Mr Bratzi. That doesn't happen. There's then this discussion on the 1st of September 2008, and although I don't think the evidence is entirely clear, it seems that that's where the 66 number, and you'll recall Mr Barazzi's evidence that he thought 34% was too low, 88% was too high, and something around the 60 mark was appropriate. So September 2008 is, and you'll see this in the second box on page 55, is when the 66 number appears, and it never leaves for all material times, I say, after that. I've already shown you, my lord, if you go to the next page, page 56, the 24 June 2009, now letter to the governor. Now, my lord, we've only got a very basic, that document that you see at 1525 is only very basic. And this, I'll keep coming back to it, but it is important. This is where the absence of internal documents from the DIFC, out of their own choice, is important, because I've shown you evidence that we say makes it very clear that the 66% mix was GFC proofed because of the timing. We're now in the summer of 2009. The crisis has globally been raging for some time now. It certainly hit the DIFC. And you would imagine that in the working papers and the underlying memos and the informal discussions and the email communications, they would have addressed that issue. That it seems highly unlikely that such a memo would go recommending these things without a consideration of the crisis and its effects on the mix. And my lord, just to complete the discussion we've had, I've already shown you, if you look on page 57, I've already shown you the JLL report. The DRC master plan changes in June 2016 and September 2007. There's further increases on that. So absent some compelling contemporaneous evidence saying that 66% had to change in the summer of 2012. That's why I make the submission that I do, that it's where you can start. Now, I'm not throwing Mr. Williams a hospital pass. He was a number 10 in his rugby days, so he knows all about those. But this is not one of those, because I simply say it's a different inquiry. He is presenting calculations on a particular basis for quantum purposes. In an inquiry as to breaches in the summer of 2012, I am simply addressing a point that I say you can be satisfied there's sufficient certainty on. My lord, turning to the next topic of the BUA and the GFA, this I say is more straightforward, but it's presented for the same reasons as the other points, because it's background. There's no change in this by the summer of 2012, but also getting there was tortured. And if you look at 24 April 2007, this is Mr. Barazzi's idea being agreed that it's 17.5% to 32.5%, with the BUA increased to 1.75 square foot. Now, apart from it's not satisfactory that there were changes and parties got confused and that costs time, and we say it's therefore a historical example of breach, I don't need to press this any more than the points I've made. Probably the most significant is this, that between that agreement in April 2007, if you drop down to page 62, 28 October 2008, it's not until there that you get final agreement that the GFA is 1.7 thousand square foot. And that is with the shareholders agreement having had a different approach, which is total BUA. And you see that on the 19th of February in the second last box on page 60. And leaving aside the JLL report, the final entry in this section, my lord, is that the master plan as at 2016 confirmed it at 1.75 million square foot. So that we can simply say, take off your list. You have the history of the breach. In terms of could the DIFC escape its best endeavors breaches in the summer of 2012 because something had gone wrong on GF. That. My lord, if I could now please turn to the affection plan. This is not something that we say was all in the DIFC's court and they messed it all up and it's all their fault. Rather, it seemed to take an inordinate amount of time once they agreed that they would be the ones that took the steps. There's no transparency in terms of what was going on. And most importantly, it's an example of us taking a position where we compromise our interests as developer of the project to reach a satisfactory arrangement. And if you look, my lord, at page 65, the box of the 25th of February 2009, that's we say the nub point of this. There we're told it's done, but then we don't get it for another 6 months. And in the meantime, if you look at 11 March, we confirm that in our design, we will take into consideration the 12-meter wide road. And if you look on page 66, 14th of May, so this is now months on from when we're told we'll get it, it has problems. And you may recall that the testimony that was provided in this respect from Mr. Barazzi is basically saying that TCOM had just had things noted in their document, which was standard form, and it didn't they didn't reflect the restrictions that we were concerned about. So I'm not suggesting the difference between May and July is on them, but it's part of the puzzle. So in terms of the affection plan, whatever happened historically in relation to it and whatever historic breaches may have existed, it's not a reason why the project couldn't proceed in the summer of 2012. And my lord, if I can please move now to the shareholders agreement. It may be worthwhile actually bringing that up for this purpose. So if you could go back to the J bundle. And well, the first important point is we do not agree with the suggestion that this is a shareholders agreement that exists in some other universe other than that contemplated by the joint venture agreement. There's no suggestion of that in the contemporaneous documents. In other words, the parties don't say scrap the Schedule D shareholders agreement. Let's come up with a new one that's unrelated and under some other conditions. Second of all, the shareholders agreement reflected the key components of Schedule D, and the changes that were made were changes that were agreed. In other words, if you look at anything in the shareholders agreement and say, oh, it's inconsistent, it's not because one party was imposing it without the agreement of the others. And just to take that up, if you could look at page J37, the definition of land, the master community declaration, and the definition of project on that page are all things that you saw in the JVA. So in terms of subject matter, that's plain. Going to the next page, J38, sale and purchase agreement, we say that's plainly the Schedule C one. My Lord, if you look at the conditions precedent, which we see on J39, those leaving aside that it's CHL are what the other key parts of clause 3.1 of the joint venture agreement. And I might just deal, if I may, with CHL at this point in time. That doesn't make this a different arrangement. Forget about whether it was in fact the DIFC that imposed CHL for their own reasons. You've got Hexagon, they're the counterparty. They've got the ultimate beneficial owners. They've passed all of the scrutiny on countless occasions. They're doing the project as required. The fact that somebody interposes another company is neither here nor there. If one party wanted to do it for tax reasons or domicile reasons, no one would say, "Oh, that's a breach," or it changes anything. So that is in our submission a red herring. And yes, we respect the corporate separate personality of CHL for the purpose of this agreement. But for your determination of the case, we say it doesn't make any difference. If you go down, my Lord, please, to J40, and you'll see the board. And that's further confirmation of the point I've just made, but also that in terms of the day-to-day running of the company and what was envisaged in the amended joint venture agreement, that the day-to-day running of the project company, this is all consistent. If you could then please go to an important section, shareholders' duties, consideration, and working capital. This is J44. And again, it's entirely consistent with the JVA. Shall execute the development and construction of the project, materially the same definition, use its best efforts to arrange in a timely manner all liquid finance necessary to meet the company's project capital and working capital needs from time to time. And then it's got those additions, and the evidence on that is very clear. They changed the shareholding, they changed the BUA, and this was something that was thrown in as an option. And if you look at 7.1.3, there was also funding provided shall be provided by an unsecured interest-free shareholders loan only in the event of winding up the company and provided all other liabilities have been paid. So not only from the question of this document, but also the evidence of Mr Al Najar, yes, this was something that they were happy to receive and took into consideration, and indeed there were discussions with various financiers, but it wasn't the only option. And my Lord, going down further into 7.1.6, you'll see there that CHL may at its sole discretion, subject to maximum permitted by DFC, increase the initial total build-up area to 1.75 million square feet. Now, You see, if you could go please to miscellaneous on page J53. (24.2). I don't raise this as a legal matter to overcome the point about the condition precedent, but I do say this: when you see in December 2009, so nearly 2 years after this document has been signed, somebody on the Hexagon side chasing up on the clause 2 condition precedents, that rather suggests to you that although they're passed, certainly the parties were operating on one of two premises. Either, yes, this agreement could still be performed, or that certainly the commercial aspects of it still applies, and that the important questions of the share purchase agreement and the company and the transfer of land ought to be undertaken. In other words, it can't lie in the mouth of the DIFC to now say, oh, there wasn't a shareholders agreement and you never presented one, and that's why we didn't need to use best endeavors. If we, rightly or wrongly as a matter of law, but as a matter of practice, are saying in December 2009, that's what we've agreed, commercially, that's what we want to do, can we please get on with it? And then our next suggestion is, well, let's remove CHL and use pieces of this. It can't be said that we weren't complying with our side of the bargain. And if it caused such a problem at the time and was such a difficulty for the DIFC, you would again expect to see it. We don't like the idea of, we want the old shareholders agreement, or we don't like the idea of Hexagon, but you don't see anything. And that means they're not being transparent, they're not cooperating, they're arbitrary, they're not playing their cards open to us, and they're certainly not doing their first best, not their second best, to get this done. So, my lord, if I could leave the share.
Are you now saying that the parties did work on the basis that the 2008 shareholders agreement was effective?
No, my lord, not as a matter of law. I mean, those condition precedents are pretty clear and they weren't complied with.
No. So, I understand the position as a matter of law, but I had understood your case and your evidence to be that the 2008 shareholders agreement was not treated by the parties as effective over the course of the next few years.
Not treated as legally effective, because I don't think that was on the evidence that wasn't available to them. But in terms of a clear agreement between the parties as to essential commercial terms, yes. And that is particularly made good by the documents I'm going to come to next, which is the memorandums, because that is on the basis of that evidence. I don't think it's available to me to make the submission to you that they proceeded on the basis that it was a binding agreement and was therefore enforceable by them. But it does allow me to say they didn't drift away from those essential components in the memo. Indeed, it was really the hexagon structure that they were most focused on. And well,
I may have misunderstood the position, but I had thought that Mr. Abdallah Al Majid's evidence was, when cross-examined on the point, that he didn't treat this as effective commercially or in any other way. Questions of law, of course, another matter entirely, and no one suggested that they looked at it and thought about it as a matter of law at the time. But I have misunderstood that.
I mean, to be fair to Mr. Al Majid, I think his evidence was to the effect that we had this arrangement. It was signed by some people, but never came into legal force. We wanted to get on with the project. We were asking them to do a series of things, and then come 2010, I got King and Spalding involved, and they sent a memo and they raised issues about revamping and revitalizing the shareholders agreement. That's how I understood his evidence.
Well, he talks about in his statement as being a draft, doesn't he?
Yes.
Yes. And I had understood at the outset of the case that both parties agreed it wasn't legally enforceable.
Yes.
But DIFCI's case was that the parties worked on the basis that it was effective, during a period of a couple of years until the 2010 memorandum. And that your case was that, no, that wasn't the case. It was only ever a draft and no one worked on that basis at all.
Yes, and I think the distinction between, I think the first part is agreed in common grounds in terms of the legal effect of it. I think the distinction between the DIFC's point that you've just summarized and ours is very small. It's very nuanced. And the nuanced difference is we never took the view that, yes, there's a finalized agreed shareholders agreement that everyone can point to and say, that's it. But in terms of the essential commercial points, their shareholding, the BUA, the flexibility on financing, those were essential things that had been agreed. And what we wanted in 2010, in March, and what we wanted in April 2012 was to package all that up into a hybrid that had Hexagon in the structure. And my lord, if that was wrong, if that wasn't the case, if my summary of the evidence was wrong, you would certainly want to see something from both the parties that says, in terms of the commercial aspects of the SHA and what we've reached on BUA and shareholding and so on, that all gets ripped up because we're not there anymore. And my lord, just the last point on that, when you said the DIFC's case is that the parties proceeded on the basis that it was effective, it depends what effective means. If it's legally effective, in other words, everyone's sort of forgotten that the condition precedents had been complied with and just assume that they could continue on, then that may be a position. But I don't think that, if you take that view or not, doesn't, I say, or is irrelevant to, and doesn't undermine our point that insofar as when you look at September 2012, can you say to yourself, well, even using best endeavors, the parties had failed to reach a shareholders agreement or the essential terms of a shareholders agreement. I say that's not an argument available to the DIFC because clearly what was here and what we referred to in the memo suggested, yes, they had been able to. And there's no reason why, if they had been complying with their obligations, it wouldn't have been completed. And they can't, by reference to contemporaneous evidence, point to any aspect and say parties exercising best endeavors couldn't have got there. And one example is, was it Hexagon or CHL that held the shares in the JV co? And turning to the detail on the table, my lord, again, it's a background point, but also a satisfaction, we say, of performance. If you look at page 70, actually, let me, my mistakes, apologies. If you look at page 68, 8 May 2007, there seems to be some confusion or debate about when they first received a copy of the shareholders agreement, in particular whether it was received in December. But in any event, there's a meeting on the 7th of May, and then it's resent. And there's no doubt at that point in time, there's engagement by the parties in the draft. If you then, there's much back and forth. And we say that the period of time here is an example of them not using their first efforts, but probably their second efforts. And for example, look on the 13th of June on page 69, there's a promise that it will be done on the following day, 14th of June. And we still don't get it. Then on the 22nd of June, that's when any commercial relationship, when the two more senior people start messaging each other about things that haven't been achieved, you know, something has gone wrong. And then on the 2nd of July, we finally get the draft holding their agreements. On any view, my lord, it is not using best endeavors or acting in good faith to take 7 months to come back on a document that's heavily prescribed and in circumstances where you've already done the hard bit of agreeing what the commercial terms would be in terms of shareholder split and BUA. We then come back, there's a meeting 2 days later, and then we come back on the 7th, which is 5 days later. So insofar as the DIFC case is, oh, you never gave us a shareholder agreement and you goofed around, that is just not a sustainable case based on that kind of chronology. There's Mr. Al Najar's meeting with the governor and Mr. Barazzi, when we're told it should be ready by the end of the month. And my lord, I will leave for the purposes of your deliberations the detail there, because it's what's significant about it is it's not until the penultimate box on page 71 that we actually get the shareholders agreement signed. Now, my lord, at this point in time, I might just take up, if I may, the memorandum at J4. And if you could please look at page J62. Actually, my lord, I probably should have shown you J61 because that's where the shareholders agreement is described. And I would say that is neutrally described in a term that's consistent with the way I've submitted to you. In other words, it says it's entered into, but there's nothing said about its force or what happens next. In B, the proposed legal structure, the essential point there is the shareholders agreement attempts to introduce a revised structure different to the one proposed. We say it's better to proceed with the JV structure, and this is it. And the really important change is Hexagon rather than CHL. And then this is the really important paragraph, my lord, at the bottom of J62. The shareholders agreement and the AJVA contemplate the formation of the company. That hasn't happened. We would suggest the shareholders agreement needs significant revision in order to reflect the correct structure for the project. And to that end, it would prepare a new shareholders agreement incorporating elements of the shareholders agreement and the requirements stipulated for any such agreement set out in an amended JVA. It is our opinion Hexagon and not CHL is the appropriate company to be involved as a shareholder, etc. And then, my lord, you then go on to the starting point for the new shareholders agreement would be that the DIFC contributes the land. Well, that's hardly a controversial point at this time. And Hexagon contributes the agreed working capital of the project company. And what you then see in the balance of that is, again, consistent with the AJBA, consistent with the shareholders agreement. And there's absolutely no reason why, as at 2010, given everything that's passed, and that this doesn't raise issues at all with the mix, with the BUA, with the percentages of shares. There's absolutely no reason why the parties ought to do it. In many ways, my lord, this step here ought to be the easiest thing the parties have done. Basically taking the old shareholders agreement, putting Hexagon back in, noting this structure, and doing the things that we said you ought to do at the end of 2009 when it was unhealthy for the parties. My My Lord, other than repeating those points and noting that there was no response to this memo, my submission, the next one, that doesn't materially change in terms of substance. You may say, why say the same thing in April 2012 that you said in March 2010? That's because we've been stonewalled and ignored, and indeed they've asked us for something, and that's why we give it to them. The essential point here, my lord, is that if we had sued them on the 1st of June 2012, we had said in our particulars of claim, this project's viable, both parties agree and want to do it. We, Hexagon as an investor, have been approved. We've agreed the BUA, we've agreed the mix, we've given them a concept design that does the job on efficiency. We had an SHA that we say has the essential commercial terms, but we want to put Hexagon back in. They drafted an SPA and we shared comments. The articles of association were close to there, and we were talking to the registry and the DIFC lawyers about the incorporation of the company. And they've blown us out for the last 2 months, and therefore we say they're in breach of their best endeavours and good faith obligations to move things forward, because they haven't done what we put in our 10 March 2010 and our April 2012 memo. The answer would be, well, that's a pretty good case. That's very obvious. You did all this work, you got poised, they've gone quiet on you, you've chased them up, you've sent them these memos. All you really have to do is change a few things on the agreement that's already there and then incorporate a company, and you're prescribed as to the share purchase agreement on the C, Schedule C of your joint venture agreement. What's really wrong with that case? The only difference between that, my lord, and the case we have now is that we spent 6 years trying to negotiate a settlement. As I'll come on in a moment, that is not something that we say, as a matter of law, ought to be held against us. My lord, I'm making good progress. I've really only got 2 more topics to cover on this. As always, my colleagues are insightful as to telling me that I'm going on too much on some things or whatever. If we were to take the lunch break now, I'm pretty confident that I would finish within 20 minutes of the lunch break concluding and be able to hand over to Mr. Williams, who will be dealing with quantum.
Well, whatever's convenient. Yes, where are we now? Yeah, all right, well, let's take 3/4 for now.
Thank you, my lord. So I make that we come back at 20 past 12.
Yes.
Thank you very much.
Yes, Mr. Strange.
My lord, the last topic I need to address you on relates to the combined question of the joint venture company incorporation, the SPA and the articles. These naturally fit together because they're effectively symbiotic, and they also, in reality, need to be detached from the shareholders agreement, because as everyone has observed, as a matter of practice, it makes sense to get the shareholders agreement in place, but before you carry out these activities. Now, the fundamental point we say is this: if you accept, as I have submitted earlier, that insofar as the essential project computation and commercial terms were concerned, the parties had reached an agreement and consensus by the end of 2009, beginning of 2010, and that those arrangements were current and effective as at throughout 2010, 11, and 12. The only real issue that was outstanding was the implementation of Hexagon as the party in the shareholders agreement. Nothing further on that score. and then the incorporation of a JV company, a share purchase agreement, and the articles, and then the transfer of the land. Now, those activities are, on any view, more straightforward. They're effectively mechanical exercises that require parties to agree documents that are less contentious and have them filed. And what we say is there are the following important points flowing from this. From the outset, rightly or wrongly, we were pestering them as regards the JV Co, the share purchase agreement, the articles, and the transfer of land. I accept that but both parties have an obligation to use best endeavors and good faith to pursue it. But for reasons which I'm about to articulate, it seems pretty clear that the parties accepted that insofar as those steps were required, it was the DIFC that would have to take the running. So other than ensuring that all of the other steps that lead up to the incorporation of the company and the SPA and the transfer of land have been agreed of execution, I say there's not much more other than pestering them that we could have done in terms of best endeavors and good faith to get these steps achieved. Now, I'm going to show you some of the detail of the correspondence where it's us asking them about these arrangements, and also where either directly or implicitly the DIFC is assuming responsibility for these activities. And finally, I'm going to just show you why we say the incorporation of a DIFC company at this point in time was quite different from incorporating a company in England. There's a permission and a discretion in the DIFC registrar that would allow any application to be dismissed or rejected with no right of appeal, which is rather why we say the DIFC took responsibility of this throughout. My Lord, if we could start, please, on page 74. We've broken them down into each of them, but they, as I say, they do overlap. And I'm going to just take you to the specific references that are unique for each one. So on page 74, you'll see this is the period of time during which the shareholders agreement itself is being negotiated and it's being provided, and there's been a meeting about it. At that time, Mr. Mehta is already chasing Mr. Ferris of the DIFC with respect to the incorporation of the JV Co. I'm not saying at that point in time it's absolutely ripe and they could have done it, but it was certainly, if the point in time was for them to say, you do it all, we're relaxed, and here's the necessary piece of paper to show the registrar, it would be a different story. That continues, and if you could please go to page 75 to the 20 February 2008 box. So this is immediately after the shareholders agreement has been signed off by some of the parties, and what Mr. Mehta is doing there is he's pressing on with the incorporation documents. And he does that because if you look at the box above, that was something that had been discussed earlier. At the very earliest, and immediately thereafter, commenced the company incorporation process. If you then look, now there's this memo from Mr. Barazzi to the governor that's undated. We think it's a fair assumption to conclude that it was post the signing of the SHA, given its contents. And then there's a reference there to the incorporation of the entity. So we certainly know post February 2008, the DIFC were on board with incorporation. You then get to September 2009, and Mr. Al Fadl is pursuing the incorporation of the joint venture company. And he's told by Mr. Farouz that DIFC management approval would be required in relation to that. If you then go to the next box, please. And I think there must be a typo that I'll double check with my colleagues, but on box 70, September date, I think 2008 and 2009. So let me check that and we can make a correction. If you then go to February 2009, there's minutes of the meeting, and that is, although they're not signed agreed minute, there are track changes that seem to represent the DIFC's views. And then you have DIFC assured CHL to use their officers to incorporate the company without any further delay immediately thereafter, etc. So the position has gone from us asking them to do it and them making various indications to, on the basis of that evidence, it being something that they will do and that they're taking responsibility for. We then move on, my lord, to December 2009, which is the third from bottom box on page 76. And that's where we are making the point that the new code should have been incorporated a long time ago and that the situation is unhealthy. You've seen the memos and what we've said in the March 10 and April 12 memos about the JV company having to be incorporated. We then, the next piece of relevant evidence we say is in March 2015, you have the Baker McKenzie advice, and there was a summary of that prepared internally, and then the advice itself. Now, it's a reasonable assumption, we say, I don't have evidence on it, but I say you can infer that Baker McKenzie took instructions and had access to documents when they prepared that advice, because they reached the conclusion that you see in little 2. The DIFCA has never attempted to start the process of incorporation of the JV company, nor has it made any endeavors to procure that. Other parties do so within a timely manner. Now that, if it takes the heights that I suggest, or even less, is rather extraordinary when you look at some of the material that I've shown you earlier. In terms of the DIFC saying, yes, we'll get on with this as quickly as possible. My lord, that entry that I just mentioned, 15 September 2009, it's actually accurate insofar as date. It's just out of order. So if you could please assume that the last box on 75 should in fact fit as the third box on 76, and we will, with your permission, we'll send you a track change of those pages. My lord, in the final box on page 77, what we've put in there is the company's law, and you'll see there for a DIFC company to be incorporated, this is the law 2006, Article 13, permission is required from the registrar, and they may reject it, and the grounds are rather broad. For such reason as he believes to be proper grounds for refusing such registration. Not be bound to provide any reasons for his refusal, and his decision shall not be subject to appeal or review in any court. So you can see that that's both powerful in terms of scope of what can be done, and final in the sense that there's no appeal. That is particularly interesting when you consider the fact that on one of the email communications, which I'll flag up for you in a moment, you had both the DIFC lawyers and the DIFC registrar involved, someone from the registrar's office, my apologies, at the time, and Mr. Barazzi confirmed that they're on the same floor. So I'm not suggesting they're the same entity. I'm not suggesting that the registrar blocked this for nefarious purposes. What I'm saying is that you can see why, in the normal course of events, the DIFC assumed responsibility for this, because it was really something that they were going to do. And more importantly, how in England, as we say there, there's no discretion in the company's registrar. It's an administrative process. Without being too crude about it, my lord, I could incorporate Mickey Mouse Buckingham Palace Limited, put in the business plan or the articles, I plan to develop a theme park at One Buckingham Palace in the garden, and that would get registered in England without a heartbeat changing. I suggest that if I did anything in the DIFC to suggest that I was going to, in articles, develop a plot of land that was owned by the DIFC, there would be very quickly a question from the registrar to the DIFC office saying, what's going on here? Has this all been approved? And for that, you would basically need most of the completed. So, my Lord, as far as we are concerned, both as a matter of evidence on the chronology and the parties' dealings, once the commercial aspects had been agreed and were out of the way, these mechanical exercises were very much, for good reason, in the hands of the DIFC. And there's never been a satisfactory response to that message that we see in 31 December 2009 F200. NewCo should have been incorporated. The situation is not healthy. They've never come back and said, they've come back and terminated for the effluxion of time, but they've never come back and said, well, the reason we're not doing it is X, Y, or Z. But Lord, if I can move on to the Articles of Association, which starts on page 78, there were certainly drafts involved, so they were prepared and shared and comments exchanged, and you'll see the references there. During that period between 24 February 2009 and 31st March, that is when somebody from the Registrar's Office appears to be involved in the negotiation of the draft articles and the incorporation of the JV company. And in that same box, we put reference to Mr. Barazzi's evidence in that regard. What happens from that point forward is further chasing following exchange of drafts. So in April, Mr. Mehta is dealing with Mr. Farouz with respect to arranging a meeting to review and agree on the structure of the company according to the SPA. There's a markup of the articles. And then there's chases internally. We would appreciate an early response. And then further chases. Now, you may recall during Ms. Calaresi's evidence, she had nothing to offer by way of explanation, although she confirmed that she interacted with Mr. Farouz as to what happened in this regard. And we say that's another unexplained but fatal problem for the DIFC on this particular issue. Because for you to assess, and this is both looking at it from the point of view of our case on breach, but also their case on they complied with their best endeavours obligation and there is no breach. And your point, my Lord, on certainty, is there sufficient certainty and contractual obligations for you to adjudge compliance? You would have to have an explanation for them as to why, despite everything else and the advanced nature of this, and that it's mechanical and it's in their own in their own building, why it didn't get done. And you simply don't have one. Just to close the trifecta of those three things, my Lord, that's the SPA. Now, again, there was an SPA that was prepared. We see the reference for that. And there is also communications in late December 2007 regarding that. This is Mr. Al Najar raising with the DIFC and discussing the question of both the SHA and the SPA. To an Al Najar discussion, and this, you may remember, my Lord, is on the cusp of this shareholders agreement being signed. To sign the SPA within a week from that meeting date, but unfortunately we didn't see the SPA for reasons you know, as reasons relating to matters within DIFC control. So again, like with the articles, like with the JV company, there's a draft in circulation, and the representations, and then the failure to follow through on those is with the DIFC. And my Lord, what you really get from that point on is more pushing, and I particularly draw your attention to 5th August 2009. This is to Mr. Mashawa, also known as George. We really need to expedite the execution of the Articles of Association and the SPA, as this has dragged on much longer than anyone would have expected. And that, my Lord, is a fair observation, as I say, given that it's a mechanical exercise. My Lord, I'm going to leave the project finance chronology for in the interest of time, and also because I say it's clear from the final document in that that even as late as April, we were saying that we would put, so this is the top of page 82, 200 million AED in as fresh equity. Now, you heard Mr. Visser's evidence about the importance of us putting in, to summarize it in the Southern Hemisphere, put up or shut up was essentially his point on the equity. We said that in April 2012. If this was really something they were disturbed about and didn't believe us, rather than sending us the renunciation letter on the 12th of June, what they should have said is, great, when and how? And yes, we'll put Hexagon in the shareholders agreement and let's do it. So that's that, my lord. And then lastly is the purchase price chronology. And all I have to say here is this is one of the project computations that changed. And I say this is a good example of the JVA and the terms that I've taken you through earlier today working, in the sense that as time went by between December 2003, when that agreement was first signed off, and when the SHA was signed in February 2008, there was an increase in the price because the market changed. So there, I would suggest you have best endeavors, good faith, to vary as appropriate project computations working, and where that gets you to is an increased amount. And my lord, it's a number that appeared in the SHA, and also in that undated, but we think sometime after the SHA memorandum from Mr. Barazzi to the governor, which is the last document there. It's referred to in there as the number. So my lord, drawing all of these strands together, it's not the only, but one of the critical questions you have to decide is whether during the summer of 2012, three things. Were they in breach of their best endeavors and good faith obligations? Had we done the work required to be able to rely on those breaches? And is there a sufficient certainty in what was outstanding for you to adjudge their breaches? And that I say, and I can simplify it now because we say the evidence is pretty clear, you had a viable project, mutual obligations to pursue it, an improved investor, the tricky project computations, including BUA, share, and purchase price for the land agreed, and the mix. Concept design not entirely there, but the hard lessons had been learned and someone was in place. An SHA largely there, but needed some change in structure that was fairly straightforward. Then just the mechanical exercises of the SPA, the JVA, so the JV code and the articles. Now, we say there's absolutely no reason why at that stage best endeavors wouldn't have got those last lingering issues done. So per se, there is a breach of those obligations. But it goes further than that, my lord, because the DIC have never explained why in the summer of 2012 they didn't just follow what we'd suggested in the two memos, adopt the commercial terms that had been agreed, and carry out the mechanical exercises that we had been asking them to pursue for a long period of time. And it is too late now, in the context of this case, for them to raise arguments about the things we didn't do, or the fact that the world may have changed and you can apply different parameters to the project computations. For two reasons. None of those were raised with us. And second of all, and more importantly, the contemporaneous evidence that I've gone through with you, things like the mix as established in the summer of 2009, post the impact of the global financial crisis, the JLL feasibility study, and what we said in our presentations all suggest that any fallout from the global financial crisis hadn't altered the fundamentals of the parties' commercial agreements. So, my lord, that really leaves the question of whether our subsequent termination was valid. And on that, my lord, if you look at their skeleton in terms of affirmation, they whittled down from about 10 documents to 3, and I will wait to see what Mr. Montague Smith says about it. But in the examination, witnesses seem to narrow down to 2 documents. And what we say is you can take a sentence or a snippet from without prejudice or even open communications between parties throughout the period 2013 to 2018. But none of them are clear and unequivocal representations by us that the settlement negotiations are over, that we've forgiven them for everything, and we just want to get on with the joint venture agreement. And that really is the only issue to grapple with during that period, if you accept what I've already said about the 18 October 2018 letter not being a genuine withdrawal of the renunciation. With that, my lord, subject to any specific questions on those issues, I will hand over to my colleague, Mr. Williams, to address you on quantum.
Thank you very much. Yes, Mr. Williams, I hope your domestic situation is all right and it wasn't as bad as was feared.
It's much better, my lord. Thank you for your inquiry.
No, well, I won't inquire further unless you wish to impart anything further.
Yeah, it's one of those household accidents you never want to happen again. Let's put it that way. In any event, things are much better now, and I'm pleased to be here to address you on quantum for this case. You have my closing note, which sets out our position on quantum, together with numerous references to the authorities and to the record. I don't propose to give you a lengthy speech, but rather to address you on key points and answer any questions you have. It's very clear that every participant in this project, the principles of Hexagon, the principles from the DIFC, both experts all agree that plot PAA1 is in a prime location in the DIFC, and that the DIFC itself is a pinnacle of the Dubai real estate market. One only needs to look at the DIFC's press release of last week as to its financial results for last year to support this. My lord, it's inconceivable to suggest that a project on this site will not be profitable, or that a right to develop it has no value. To use Mr. Brand's words, it's part of the best undeveloped portion of the DIFC. It's Berkeley Square, to use Mr. Williamson's analogy. Further, if you look back through time, Mr. Brand's own company, JAL, in 2009 confirmed that a project on this site would be feasible. And so you have it, my lord. The reference for that is F3 tab 201, page 1577. That's the JLL 2009 feasibility report for a project on the project site. The immediate questions in assessing compensation are what project to assess and at what date. I'll address you on both of those points, but just as a preliminary observation, when we come on to consider specific inputs, and in particular 3 inputs that are really very key to this inquiry, and the potential sensitivities to the models that one might apply, it may well make not much difference to the outcome, whichever project, either the approved or the HBU project, and whichever date, 2013 or 2018, you adopt when the numbers in the model are flexed a little bit, just to take into account potential findings on individual inputs where there were differences between the experts. But turning first to the overarching question of what project should be adopted. As you're aware from opening and from the evidence, Mr. Williamson looked at at two projects. One was what he termed an approved project, and the other was a highest and best use project. So just focusing first on the approved project, this adopts a built-up area from the AJVA of 1.45 million square foot and a mixed use from the 2016 DIFC master plan, which was 97% offices, 3% retail. And the rationale for the approved project is to remove any element of subjectivity from the inquiry as to what would have been approved had the project gone ahead. There was obviously some discussion about the appropriateness of adopting the 2016 master plan, DFC master plan mixed use for a 2013 valuation, and Mr. Williamson's answer to that was that, in his professional opinion, that would have been the mixed use post financial crisis that would have applied in the DIFC in 2013, and indeed it was a reference point that was proximate in time both to the 2013 consideration of the project and the 2018 consideration of the project. Indeed, he referred in his evidence to a DIFC document which suggested that 2016 DIFC master plan mixed use had in fact been circulating within the DIFC for some time, and that document is in the bundle. It's an 11th of August 2013 document at F bundle 5 tab 277 page 2514, and that's very clearly marked a 2013 document. You have to blow the document up. It's an A4 map of the plot, and it lists the 97% office, 3% retail, 1.75 million BUA for this plot, and there's a very faint date on it, which if you either take out your magnifying glass on the hard copy or you zoom in on a PDF on screen, you can see that date was in existence for some time before 2016. Maybe it's helpful to turn to that. My lord, so that's if you have the document, it's plot PAA1, and it's featuring at the back of a report prepared by Knight Frank, which was, this is a very lengthy tab, and the first document is an email from Jack Visser to King and Spalding, and this is a Knight Frank report shared by the DIFC with the parties in July 2017. But the plan on the last page, if you put the document into a portrait orientation, very faintly you can see DIFC Dubai master plan, and there's a very much fainter date of 11th of August 2013. So that was the document Mr. Williamson was referring to when he suggested that 2016 mixed use would have applied on the 2013 date as indicating what was approved within the DIFC post financial crisis. And to answer a question that arose at points in time since opening as to the mixed use that featured in the AJVA on page 18 of tab 1 of the J bundle, it's important to recognise that, you know, whilst a contract may set out a mixed use and a BUA, ultimately, you know, the parties are going to be guided by what's in the DIFC master plan, subject obviously, of course, to variation and amendment amongst the parties and the DIFC. But in our submission, you know, neither that mixed use within the AJVA nor the mixed use in the 2005 DIFC master plan, which is the only master plan in existence prior to the 2016 version wouldn't have been an appropriate assumption to make in terms of an approved project at 2013. In terms of the HBU project, that's adopting the highest and best use based on work Deloitte undertook for the parties as part of Project Access in 2018, and that was 66% residential, 18% serviced apartments, 12% hotel, and then a very small proportion, 2% retail, 1% offices. And in Mr. Williamson's HBU scenarios, he adopts a BUA of 1.75 million square foot, consistent with the 2016 DIFC master plan. So that scenario is intended to reflect the project the parties most likely would have agreed had the project gone ahead, rather than the base minimum in the approved project scenario. And the record from 2018 it shows quite clearly that those computations in the Deloitte Project Access that the party was discussing in late 2017 through to early mid 2018 they were very close to moving forward on a project on that basis. So in our submission, it's a reasonable reflection of what might have been agreed above and beyond what's set out in the DIFC master plan. My lord, we touched on a topic in opening as to why the straight loss of profits calculation for the HBU project did not appear to be as profitable as the approved project, and how, that being the case, it could be classified as a highest and best use. And if you recall, I alluded to complexities within the model and differences in the timings of cash flow based on the differences in mixed use, where you have a significant proportion in the HBU being residential sold off plan early versus in the approved project pretty much exclusively office bar a small amount of retail, and how that produces in the approved model fairly lengthy cash flows on rent, which is what accounts for the higher end result in terms of revenues and profit in the loss profit, the straight loss profit calculation. And the reason the HBU project represents the highest and best use is because it's the most market-facing mixed-use scheme that, if it's developed, would likely match the market demand at the time that it was prepared by Deloitte in 2018. So as I said, the largest component of it's residential, the majority of which would be sold off plan during the development stage, whereas the smaller uses, the retail and the offices, will reach stabilization relatively quickly, so you capitalize them earlier, whereas in the approved project, the rents from the offices only kick in after the development stage, so 4.5 years into the model, and then they extend for 7 years until you reach stabilization, and then you capitalize them. And the result of that in the model is that you end up with a higher loss of profit in the approved scenario than the HBU. But that's not necessarily to say it would be a no-brainer for the parties to run with the approved project rather than an HBU, simply on the basis of that's the way it's played out in the models on this damages assessment. Because
I don't follow that, Mr. Williams. I can understand there might be cash flow reasons for adopting one course rather than the other, but you'd have thought that highest and best use must, as a matter of the hypothesis on which it's based, result in a better result than approved. And if it doesn't, one's instinct is to say something's wrong somewhere. And what is the answer to that?
I think there's 2 points. The first is that the highest and best use gives you early revenues from the off-plan sales, which you then
I understand. Now
apply
that's
into
cash
your
flow.
initial
Yeah.
construction costs. So it may be a cash flow decision that's the highest and best use. The other answer is that there was a certain, and the experts touched on this, there's an artificiality in the models in that it's based on the assumption as soon as you reach stabilization, you cut and run. So you're only looking at an 11-year period, but in reality, it's not to assume that the UBOs would sell out the project at that point in time. So it may well be that stretching further into the future, the HBU project is the one that is going to match market trends better.
Well, I mean, that just suggests the calculation's wrong, doesn't it? Because X hypothesi. Anyway, there it is. You've said what I think can be said. I see the cash flow point.
Yes. Okay. I'm grateful, my lord. And the only thing I would conclude on that point is that, again, I think with much of this, and Mr. Williamson was replete with this statement in his cross-examination, that none of this is an exact science. And when you look at each model and you think about how certain bits might be stressed and flexed, it probably all comes out in the wash, because there's not a great deal of difference between the HBU and the approved, particularly if you're looking at certain inputs and how you might apply sensitivities to those. The same applies really when considering what date the assessment should take place at, 2013 or 2018. We've cited authority in our closing note, and I'm sure those authorities, and they're on. They start from page 3 on the quantum closing note, and I'm sure your lordship's familiar with them. And I don't propose to take you to any of them for this simple reason, that fundamentally it's a factual inquiry, and it's going to require an exercise of discretion. The Golden Victory refers with approval to the time-old Lord Blackburn principle in Livingston and Royard, that the measure of damages is the sum of money which will put the party who's been injured or who has suffered in the same position he would have been if he'd not sustained the wrong for which he's now getting compensation. The factual point, we say, is that but for the DIFC's breaches in 2006 to 2012, the project would have been developed on this site from as early as 2013, and that in reality is the loss of bargain. The fact that Hexagon reserved its rights and terminated later doesn't change that fundamental fact. We've obviously found cases, and they're included in the note, where damages have been assessed by reference to an event, including termination that occurs later than the date of breach. But we say those cases are distinguishable. Johnson and Agnew, for example, involves a sale and purchase of real property, where the claimant, rather than reserve their rights, sought specific performance to compel the purchaser to complete. It was only when the mortgage company stepped in and sold the property that the possibility of specific performance was extinguished. So the date on which to assess damages in that case was the date specific performance was no longer possible, given that the seller had made that election, rather than the earlier date when the purchaser had failed to complete. We're miles away from that scenario in this case. Hexagon made no such election. It reserved its rights to terminate based on the earlier breaches if a settlement couldn't be agreed. The other cases are summed up in the Golden Victory, and they discuss sales of goods really and charter parties. They're predominantly cases involving mitigation. That's to say, you could assess the damages at a later point in time, when the duty to mitigate actually kicks in, and going back to the market either to source alternative goods or alternative performance becomes a possibility if it wasn't a possibility at the time of the breach. So again, we say we're miles away from those types of cases. Mitigation doesn't apply here. There's only one plot, PAO 01, to develop, and there was nothing the UBOs of Hexagon could have done to mitigate other than reserve their rights and try and seek a resolution of it, failing which we all end up where we are now. In direct response to your question in opening about authorities dealing directly with the scenario we have here, where there's been breach and then a lengthy reservation of rights prior to termination, we've not found any authorities addressing that specific scenario. Ultimately, the cases on assessment of damages and the appropriate date for valuation, there's flexibility in them, and there's a discretion to be exercised. We say as a matter of fact as to when the bargain was lost, and we say it was lost when the breaches prevented a project from proceeding at a point in time when, but for the breaches, it would have proceeded. Not we say crudely when the right to terminate was exercised. We say that's not when the bargain was lost. We say that the termination brings you, because of the reservation of rights, brings you back to a point in time when you reserved. And then ultimately the cases, and why we say it's a matter of your discretion is because ultimately you have to look at any damages award and satisfy yourself that the principle enunciated by Lord Blackburn has been met. One point of detail, because it came up during the course of evidence, was the 2018 scenario that Mr Williamson has looked at. That was not, as correctly observed by your lordship, was not based around the date of termination. It was based around a slightly earlier date, premised on the claimant's alternative case. The breaches had continued post 2012 throughout the period well into 2018, and so that later in time scenario was presented to address findings of that nature. But as I think your lordship rightly observed, it probably won't make much difference to an assessment of actual number, given that date is not that far ahead of the actual termination, which came later in 2018. So my submission would be that the 2018 models, work in a scenario where your lordship finds on the facts that the loss of bargain occurred at the point of termination. But it's obviously our primary submission that the loss of bargain was in 2013, and that it's the 2013 scenarios that should be taken up for the purposes of quantifying the loss.
The relevant date, because a 6-month period is allowed, is the 28th of November 2017, isn't it?
Correct. And I believe that is tied to the agreement of the standstill agreement.
Yes.
Yes.
My question is, why pick that date?
It's tied to the negotiation of the standstill agreement, constituting a further example of renunciation in the sense that Mr Visser insists on certain language, which we say is evidence of the DIFC's position that the AJVA remain no longer binding, at least from their
well, it's a non-admission, isn't it?
Yes, and I accept that it's artificial. If we look at it in terms of other dates, one could say that the so-called performance letter, 10th of October 2018, itself is an appropriate point in time to fix the loss of the bargain, or indeed the termination the following month in November 2018, and then you would add
6 months from that.
6 months from that.
Yeah. Yeah. All right.
By far the key difference between the experts was the approach taken, a straight loss of profits or a valuation, and with that the question of discounting. A finding from your lordship on that will obviously have the biggest impact on the outcome of this case. Now, Mr. Williamson was very clear in his lengthy cross-examination. In his professional opinion, the present case is an example, an exceptional one, he concedes, but an example nonetheless where discounting is not appropriate. Simply put, Hexagon was committed. Indeed, it was contractually obligated to proceed with the project. They'd spent millions of dirhams gearing up for it, with the hiring of consultants and the purchasing of not 1, 2, but 3 concept designs. As the contemporaneous record shows, the principals and various staff working on behalf of Hexagon had devoted substantial time to this project. Initial rates of returns and MPVs usually used to assess and decide upon whether entry into an investment opportunity is sensible or not, clearly don't apply in this scenario. Another reason for discounting would be around financing, the cost of financing, but the evidence of Mr Al Najar was very clear, and Mr Hossan too. The UBOs had the means to fund this project without borrowing. Mr Montague Smith suggested during his cross-examination of Mr Al Najar that people would laugh if he suggested that he had 400 million sitting in a bank in cash. That may well be true, but it's not laughable when you're talking about businessmen in the Middle East. The check for Saudi 1.5 billion riyals that Tamayat received from the Saudi Central Bank for the sale of an unencumbered project in Mecca is just an example of the level of wealth the UBOs in this case possess. A key objective for them, and this was clear in Mr Al Najar's testimony, was to have their names attached to an iconic and prestigious development right at the gateway to the DIFC. Mr Hossan testified that Mr Al Ramazan was prepared to do whatever it took to progress this project, even if that included putting up funds for other of the investors. So why is this relevant to the question of valuation and discounting? It's because whilst borrowing may have been an option in some of the discussions between the parties through the years, and it was even memorialised in certain documents, for example, the 2008 draft Shareholders Agreement, the default position in the AJVA was that the JV company wouldn't borrow and the land wouldn't be used as collateral. That being the case, there's no place for discounting on account of the cost of finance in this project and damages assessment. And this remains the case even if Hexagon or its UBOs were to borrow in their own name. Since that borrowing falls outside of the joint venture company, it's not part of the model that assesses profitability of the project with respect when you're looking at just the JV company. And you were taken to various financing possibilities that the UBOs pursued in 2008 and 2009 with Bear Stearns and CSI, and it was clear from those that there may well have been mingling of that financing with other projects and other collateral. That's a matter for Hexagon and the UBOs, and if it's not borrowing in the name of the JV company and it's not secured against the project land, then it's not a factor that needs to be taken into account in the financial model. Now, Mr. Brand hadn't turned his mind to the specific circumstances of this case. So he'd not considered whether evaluation, which includes discounting, was appropriate or not. And that was in contrast to Mr. Williamson, who had considered both the contracts and the factual circumstances, which, whilst the matter for you, my lord, indicated that Hexagon and its UBOs were fully committed, that rendered a straight loss of profits reasonable and appropriate in the circumstances of this case. And he confirmed that this wasn't by no means the first occasion on which he's been involved in a case where discounting didn't apply. Ultimately, from a legal perspective, it comes back to the Lord Blackburn principle as to what's going to reasonably and fairly compensate the claimant for the loss of bargain. In addition to points of principle, there are also calculation issues in Mr. Brand's model in terms of the way discounting's been applied. He's taken the cash flows and he's discounted them all right back to the valuation dates, when in fact he should be taking into consideration, whilst he can't know what the date of judgment would be, he knows the date obviously when he's submitting his reports, and the approach that ought to be adopted is that any cash flows that at that point in time are in the past, interest ought to be given credit, and you should only be discounting in terms of years in the model going forward from the point in time when where you're actually sitting. Mr. Williamson sought, given your lordship's comments during opening, to assist the court by preparing some illustrative numbers around this, but as you're well aware, the defendants objected to the admissibility of that material, so we're not any further forward in that regard. And what we say the implication of that is that if your lordship is with Mr. Williamson that this is one of those cases where discounting shouldn't apply, then it's obviously the way in which Mr. Brown's applied discounting is obviously a non issue. But if you're not with Mr. Williamson on that point of principle, then just as a point of evidence, the defendant's expert's failure to apply discounting in a proper and reasonable way to take into account interest on past cash flows means that you have to disregard the entire calculation, we say.
You weren't here, of course, Mr. Williams, but the fact is that Mr. Brand wasn't cross-examined on the question of discounting at all. At all.
My lord, I obviously did not intend to make submissions on a point that didn't arise in evidence.
But the problem is this. Mr. Williams, and I'm sure you appreciate, where an expert gives evidence and he's not cross-examined on it, unless it is so obviously and utterly and completely nonsense that no court could possibly take account of it, I draw the obvious conclusion. It's not challenged, and therefore his evidence stands. By contrast, of course, Mr. Williamson was cross-examined on the subject. That's in some detail.
My lord,
at present, I can't see myself as being anything other than bound to follow the evidence.
My lord, I would need to recheck the transcript. The point I've been intending to make was the opening of Mr. Brand's cross-examination. He was asked what material facts he'd taken into account in forming his opinion. Whilst he wasn't cross-examined necessarily directly on discounting, he was cross-examined on his decision or his instruction to adopt a valuation approach as opposed to a straight loss of profits approach. And so to me, within that's implicit, the discounting comes with the fact that he's adopted the valuation approach rather than the straight loss of profit. So that was the only point I've been seeking to draw to your attention. And obviously the issue of whether interest should be applied to discounted cash flows was a point that had arisen in Mr. Williamson's evidence, but we're not in a position to take that any further forward because of the DIFC objection to that material coming in. So that's where we are. But in my submission, the testimony of Mr. Williamson is sufficient enough to cast doubt on the propriety of the discount as it's been applied by Mr. Brown. And as I say, obviously it's a non-issue if you're with Mr. Williamson in principle that this is one of those cases where discounting is not appropriate. Again, with the submissions I made on which project to assess and which valuation date, it may well be that it's a matter that comes out in the wash when you look at the different scenarios and the inputs and the models, because what we're essentially talking about, the discount in Mr. Brown's model is being used as a proxy for taking into account risk, and while we say that it's not the appropriate mechanism to use because we're not in a potential investor scenario, what we do say is that risk is catered for in Mr. Williamson's models by the reasonableness and realism that he's applied to the individual inputs, and that doesn't just include using appropriate comparators to arrive at averages for things like rental income for offices. It's also, for example, you recall on the construction costs, he's built in a contingency, which his evidence was that it's the contingency more than a discount rate that covers, for example, the kinds of risks like construction costs overrunning. So we say if it's an issue, are you on mute, my lord? If it's an issue of applying a discount rate to take into account risk, we say it's not necessary because risk is built into the reasonableness and realism of Mr. Williamson's assumptions and inputs, and we'll come on to sensitivities in due course, but they can even be flexed a little more to cater for any perceived uncertainties that obviously drive the numbers down from what we say are already very realistic and reasonable assessments of the overall loss.
The only contingency that was built in was a 5% contingency on construction costs, wasn't it? Have I missed something?
That's correct. I'm talking about the contingency and the construction cost. But that's important because it's if you think of the models in very simplistic terms, there are costs on one side and there are revenue streams on the other, and the construction cost is obviously the lion's share.
Yes.
Of the costs here. So a contingency built in on that basis is doing the job of counting for the major risk in this project, and the reasonableness of, for example, comparators on offices or on hotels is doing the job of balancing the risk on any uncertainties as to what revenues are going to be generated. Perhaps it's probably now the best time to come on to some of those inputs in more detail. And there are numerous inputs. There are more inputs on the HBU scenarios than the approved. And the three key ones that emerged during the hearing, and Mr. Brand in his testimony accepted that these three inputs, so the rental income on offices, the efficiency gross to net of the building, and the construction costs were likely to have the biggest impact on the end number. And so it's those three that I think it's worthwhile exploring before coming on to sensitivities and how the models might be flexed. Just in terms of authorities, this is probably where the final authority in our closing note comes into play, and it's the dictum of Mr. Justice Leggett, as he then was in Yam Seng, which talks at paragraph 188 about how you resolve uncertainties in a damage assessment by adopting reasonable assumptions which err on the side of generosity to the claimant. And when we go through these three inputs in particular, it's patently obvious that Mr. Williamson's approach to these has been very even-handed, whereas in contrast, Mr. Brown appears to have erred on the side, if anything, of generosity to the defendants, and that goes against the precedent set in Yam Seng for how these types of assessments should be approached from a legal perspective.
This is the fair wind principle that's been commented on elsewhere, is it not?
Yes, my lord.
Am I correct in thinking there's some Court of Appeal comment on it?
You may well be, but it may well have escaped me. But we can look into that and get back to that authority if it would assist.
Well, I seem to recall commenting on it myself at some point, but I thought there was some Court of Appeal authority, but I may be wrong about that.
Even better, if we can find an authority from yourself, we would.
No, we'll find a real authority, is what I always say when people cite my own decisions.
Okay. Well, it's difficult. It's difficult finding yours because you have to look in England, Singapore, Dubai, and who knows elsewhere. But we will try. In terms of rental income, so the first input, we've put in our closing note.
Yes. Can you just take me to your relevant pages of your note?
So it's page 19 of the closing note, and we've included some extracts from the experts' reports and the transcript. And this is one input. It has a big impact on the approved project scenario because it involves rental income for offices, and obviously that scenario is 97% offices. But what it boils down to is what are the appropriate comparator developments to use when assessing the rent that's likely to be achieved in an office development in a prime location at the DIFC. And so Mr. Williamson's, he's adopted a rental income of 230 dirham per square foot, and he bases that on a comparison with the Gate and Alpha Town Currency House, which range from 225 to 250 dirham per square foot, and his opinion is, and I don't think this was controversial, that the Gate and Alpha Town form that prime area of the DIFC, and so they're an appropriate comparator. And he's made a 10% discount for the fact that our plot PA01 is across Al Mustabal Street. The issue comes, as you'll recall from Mr. Brand's testimony, is the inappropriateness of including developments spanning the entire DIFC, and in particular Central Park Towers and Index Tower. They're more than a kilometre away from the prime area, and in the case of Central Park Towers, if you've ever visited them, my lord, it's not well integrated in the DIFC at all. So when Mr. Williamson was talking about the integration at podium level in the prime area, his Berkeley Square, he's talking about a number of developments interlinked where one can easily by foot access a whole range of amenities, whereas Central Park Towers is a very long distance away, and it's not integrated in any sense. And Mr. Williamson referred in his evidence to a table in his report, and I'll give you the reference for that. It's at tab 2 of the e-bundle, so the experts bundle, page 185, and it's perhaps worth just turning that table up because it demonstrates pretty clearly the effect, the diluting effect of including developments like Central Park Towers and Index Tower as comparators, because those two developments command rents. You can see it at the top table. Central Park Towers commands rents of 130 dirham per square foot, and Index Tower is around, and there are different entries for it, presumably because that represents different parcels of office space leased, but 155 to 163 dirham per square foot. So when you throw all those developments in, as Mr. Brand has done, and Mr. Williamson has set them out in this table in his second report, you get a dilution down to 182 when you round up dirham per square foot. And so that's going to have a big impact on the overall calculation of the lost profits. There were arguments about the relevance of Burj Demand, which is the plot on the other side of Al Mustabal Street, about two lots up from plot PA01, and also the significance of ICD Brookfield, which is equally, although on the same side of Al Mustabal Street as the prime area, is behind Alpha Town House, and neither of those developments form part of Mr. Williamson's Berkeley Square simply because of the distance from the prime area. So he didn't regard them as relevant comparators for that reason, and also because he wasn't applying hindsight in his valuations. So certainly neither of them were in existence at the 2013 date, and I may be mistaken on this because I'm going off memory. Berge de Man may well have been online by the 2018 valuation date. I don't think ICD Brookfield was. So for those reasons, he's not included then. But I mean, if you look at the table on page 185, Berge de Man, which Mr Williamson accepted, was in some respects a comparable development. There were rents there achieved of 230 dirhams, so not inconsistent with the rental income rates that Mr Williamson had adopted in his model. So we say that Mr Williamson's got it spot on in terms of the rental income he's applied in his model, but he has, and we'll come on to them in due course, he's run sensitivities in his second report around rental income for the offices, and so it's open to your lordship to take a view on whether the model should be flexed. We say not to take into account Central Park Towers or Index because it's clearly obvious the diluting effect those developments have inappropriately, we'd say, on the output number. But for developments in a greyer area such as Berge de Man and ICD Brookfield, there's certainly some flexing in the model that could be done to cater for that, and I can show you those tables after we've gone through the other two key inputs. The next key input is efficiency, and by that we mean the gross to net. So the area available for letting or sale as distinct from common areas, and this input is extremely sensitive. Small swings in the efficiency have huge effects on the loss of profit output. So if you take an example of Mr Brand's efficiency of 70% for the office space in the approved project in 2013, as compared to Mr Williamson's 75%, that immediately knocks 195 million dirham off the quantification. What we say on efficiency is Mr Williamson was already meeting Mr Brand in the middle by adopting 75%, bearing in mind the contemporaneous record that clearly demonstrates that the parties were committed to achieving 80% efficiency through design critique and value engineering. The parties, and this is also set out in the record, the parties jointly terminated Perkins and Will and had abandoned the two-tower concept, and it was the concept of building two towers on the site as opposed to a single tower that was deemed to be a key constraint in achieving the desired efficiency. During the experts' testimony and also in the contemporaneous documents and reports, including reports prepared by and for the DIFC, they show that 80% and certainly 75% in terms of efficiency was achievable for a development on this plot, and we've got those references on pages 20 through to 24 of our closing note. So on the bottom of page 20, there's the DIFC Project Assets Management Department's own assessment prepared in September 2002. It's an asset development baseline for the plot PA01, where they feature residential efficiency of 85% and commercial of 75%. And then over the page on 21, there's the citation to the JLL report, the feasibility study they conducted in respect of a project on the site in December 2009, where they've adopted an office efficiency of 80%, residential 80%. So it's clear from the record that 80% is very much achievable, and Mr. Williamson has been cautious in adopting a 75%, and that nowhere in these documents is there any support for Mr. Brown's adoption of the 70%. And just referring back to the impact this has, perhaps to the casual observer, knocking 5% off an efficiency might be considered not that much or not significant, but when you run the numbers, it has this huge effect of knocking close on 200 million dirham off the quantification, and so that we submit is an explanation for the adoption of a 70% efficiency when it seems to be, it is unsupported by the contemporaneous materials with respect to this project site specifically. In terms of construction costs, as we discussed a moment ago, this is obviously the key component on the expenditure side of the model. And you'll recall during the expert testimony being shown on screen, the 6 boxes of source data that RLB relies on to produce construction costs for projects in all different parts of the world, and all different types of use developments. And Mr. Williamson testified, he described these RLB figures as effectively the Bibles of construction. And as we mentioned before, on top of that, he's applied a 5% contingency for construction cost overruns. In contrast, Mr. Brown's figures were sourced in-house, his firm JLL, and you may recall from his cross-examination that the source of this data was from a colleague of his called Matthew. And none of the underlying data supporting Matthew's figures had been provided. Matthew's not a co-author or signatory of Mr. Brown's report or the expert declaration there too. And we say, like Mr. Brown's approach on the other inputs, the objective has been clear. If you submit higher costs into the model, you're obviously going to eat into your revenues, and the profit output is going to be lower. So looking at it like for like, Mr. Brown's costs in the approved project scenario in 2013 are actually 3% higher than Mr. Williamson's, and Mr. Williamson covers that in his second report at tab 2 of the e-bundle, page 190, paragraph 3.48, and they're 26% higher for the HBU project in 2013. He also covers that in his second report a little bit further on. Page 203, paragraph 463, he explains the calculations in that regard. And so our submission on the construction costs is that Mr. Williamson's ought to be adopted because they're sourced from independent cost consultants who produce these figures based on empirical data which is transparent and fully available, whereas my lord, you're none the wiser as to the source data of the figures that make up the construction costs in Mr. Brand's report. So in our submission, those costs should be disregarded. Turning now to outcomes, we've listed on the last page of the speaking note, page 31, the where you can go to consider sensitivities. At first, just taking up the e-bundle and Mr. Williamson's first report, so tab 1 of the e-bundle and page 69. These are Mr. Williamson's loss of profit calculations in the 4 scenarios. You've got the approved project as at 2013, 1.3 billion dirham, approved 2018, 755 million. HBU at 2013 is 1.15 billion, and the HBU at 2018 is 569 million dirham. And so coming on to Mr. Williamson's second report at tab 2 of the bundle, page 212, a summary of Mr. Williamson's conclusions, and there you can see he discusses the differences between himself and Mr. Brand on gross to net ratio, and then revenue, and over the page construction costs. And it's the tables from 214 that your lordship should be aware of. And so on 214 there are 3 tables dealing with the approved project in 2013, and the top table, figure 37, deals with changes in the office rent. So this is where in the middle you can see the 230 dirham per square foot Mr. Williamson has adopted, and then you read across that is resulting in the 1.3 billion loss of profits that I just showed you from his first report. But what you can see in this table is if you stress that input, for example, 15% or more stress of that would start to take you into the central towers index tower territory, which we submit is not appropriate. But if you were to stress it to take into account purge demand or ICD Brookfield, then you're more in the 5 to 10% territory, where you're looking at the impact that has on the loss of profits, 1 billion dirham, 1.19 billion dirham. So that's a sensitivity that can be applied to one of the key inputs in the approved project, either at 2013 or 2018. And so you've got 2018 over the page on 215, and there you can see a similar flexing to take into account ICD Brookfield Tower and Burj demand of 5 to 10%. Takes you down into the 500-600 million dirham loss of profit territory. Obviously, that input on office rental has a much less significant impact on the HBU scenarios, because offices only account for 1% of the total mixed use. So the sensitivity Mr. Williamson's run on the HBU projects in 2013 start from page 216, and one input that was discussed at length during Mr. Brand's testimony, obviously the hotel ADR, which is figure 44 on page 216, and in the 2018 scenario it's on page 218, figure 50. and my lord, I'm obviously conscious of the application that was not made earlier by Mr. Sprange, and I don't intend to trespass on that in any way. What I can say is that during questions from you during Mr. Brown, at the end of Mr. Brown's cross-examination, he gave you the 5 hotels that feature in his so-called competitive set of hotels, and STR, which is the source of the data that Mr. Williamson's used for his competitive set. They publish a lot of material. It's in the public domain, so anyone can check the 5 hotels Mr. Brown mentioned, and 2 of them are sub-luxury according to their categorization. So the Rove is, I think, upper mid scale, and the Mansell is upper upscale. In contrast to the other hotel, all 5 on Mr. Williamson's list are categorized by STR as luxury. So in terms of the hotels and the ADR, it's a similar example really on hotels as it was for office rentals. The inclusion of those 2 non-luxury hotels is going to bring the ADR down in a similar way that Central Park Towers and Index Tower have dramatically brought the office rental down in the approved scenarios. But nevertheless, there's a table on ADR there where that input can be flexed in the HBU project to bridge the differences between Mr. Brown and Mr. Williamson on that input. The other piece of information about hotels and competitive sets that is in the public domain is that 4 of Mr. Brown's hotels in the competitive set are EMAR hotels, and so how you can run a competitive set when 4 out of your 5 hotels are not in competition with one another is self-evident, but there you have it. Just in terms of one final data point in terms of sensitivities, there's obviously Mr. Brown's table in tab 7 of the bundle, and it's page 364, where he makes adjustments to Mr. Williamson's models based on the differences between himself and Mr. Williamson on all the inputs collectively. Now we say that is too crude a way of doing it, because it obviously presupposes that your lordship will find in favour of Mr. Brown on every single input, but what's worthwhile drawing to your attention, even on that basis, adopting Mr. Brown's assumptions to every single input, we're still in positive territory on the 2013 scenarios. In the approved scenario, according to Mr. Brown, 120 million dirham, and in the HBU scenario in 2013, 104 million. But as I say, we submit that that's too crude. What would be more appropriate is to look at Mr. Williamson's tables, where there could be some flexing on certain inputs that are significant to the models in the scenario that's being looked at. And I say that because it comes down to, I think, the discussion you and Mr. Montague-Smith said as to it's difficult to discuss this in abstract because it depends on which year you're looking at and which model, approved or HBU, you're applying. So in terms of the tables at the back of Mr. Williamson's second report, there's really a menu of options. What you won't find there is sensitivities around construction costs or around efficiencies. I mean, Mr. Williamson's given you an indication of how sensitive efficiency is, and we submit that, as I've already made the point earlier, that the 75% Mr. Williamson's adopted already sits in the middle of Mr. Brown's position at 70% and the party's realistic objective of 80%. So we say there's no flexing the models required on that front in terms of where Mr. Williamson lands, and equally on the construction costs. He's not run sensitivities, but again, we say his evidence on construction costs is to be preferred to Mr. Brown's, simply for the source of where he's obtained that data, and we also include on our note discussion of the answers Mr. Williamson gave in his testimony about the contingency of 5% being appropriate for this project, given the extent of definition he'd seen already within the parties' discussions over the years. So that's to say that the further evolved the plan is, the lower the risk of things like construction cost overruns and delays. And then there's also obviously the possibility that you have a fixed price contract, as is fairly common in the construction industry in any event. What we would say on this subject is that if you consider those three key inputs and you form the view that Mr. Williamson has been reasonable and realistic in his approach and Mr. Brand has not, there's not really any flexing of the models required at all. And finally, on page 31, there's reference to various real world examples of the value of this development right, ranging from ICDB's actual offer of 120 million dirham in 2018. The range the DIFC itself in its September 2018 board minute put around that buyout, 88 million to 435 million dirham. And then in the middle of those two references on page 31 of the closing note, there are the sensitivities that Deloitte ran around various scenarios when asked by Mr. Al Najar on behalf of Hexagon to consider the range in which offers might be considered, and with no discounting, that range was 745 million to 980 million, and with some discounting, the range is 215 to 335 million. So we include those just to give a cross-reference for two reasons. One, to say that nobody's ever talked about this project as being not feasible and not profitable, and two, they show that the loss of profits that Mr. Williamson has calculated are not by any means out of this world unrealistic. So unless I can be of any further assistance, my lord, and just giving me a moment to check with my colleagues, those are my submissions on quantum.
Do you want to say anything about reliance loss?
So we discussed this in opening, and the principal the principle that the actual expenditures spent on this, which we detailed in our opening note, the assumption should be that revenues from the project would at least allow recovery of those sums. So that's our position on.
So you're not really putting it on the basis of reliance loss. You're putting it simply on the basis that, at the very lowest, that's what your expectation loss amounts to and can be measured in those terms.
Yes, it's put forward. It's put forward as a cross-check, as you often see, effectively the market approach acting as a cross-check to the loss of profits calculation.
No. I'm not talking. I'm talking about the sums that are sunk, the wasted costs, so to speak. I'm not talking about the other ways of valuing it in terms of sale to a third party.
Yes. Oh, I see. Yes, we are. We've put those in on an expectation basis that the expectation would be that if a project was developed, we would at least recover those costs.
Okay, understood. Now, can you just give me the bald figures for construction costs as put forward by the experts? My recollection is Mr. Williamson was 400 million, 398, I think it was. What was Mr. Brand's figure?
Well, it'll differ across the two scenarios, and I'm minded to turn to the cash flows at Appendix 9.
Thank you.
At his first report, so that's tab 1, starting from page 102 in the e-bundle. And so there's the approved project 2013.
Yeah.
And there you've got in the left column, you've got totals. So you've got construction costs for the retail and construction costs for the office.
Yeah, no, I was rather hoping you'd simply come up with some global figures for me.
I think we can certainly do that, and perhaps we'll submit them in a short note to you rather than take up your time now.
Well, if you could just put them on a bit of paper for tomorrow, that would be helpful. I just want to see what the comparisons are between the actual cost figures.
Yes, we will be, my lord. Understood. And I guess, given your question about the sunk costs, I don't know if it's helpful to discuss. There's the price Hexagon UBOs paid to obtain their interest in Hexagon, which I can rather accept by the look on your face is a dead duck. But looking at it more from the perspective of valuing an investment, right? So those cross references on the bottom of page 31, as well as being a market approach as a sense check to a lost profits, can also serve as a reference point for assessing the loss of a development, right, as opposed to a loss of profits. So they're there in that respect as well.
I'm sorry, I'm being rather dense here, Mr. Williams, but I was just thinking in terms of the 8 million odd that is referred to as sunk costs, money spent on architects, consultants, etc., etc., etc. And I was trying to see where that fitted in with your case. It's pleaded as part of the loss and damage in the amended points of claim. re-amended points of claim, and Mr. Strange told me at the outset that wasn't an additional claim. That was, he said, an alternative was reliance loss. But I'm unclear whether that is being pursued as reliance loss or whether it's simply the very bottom end, so to speak, of what you say is reflective of expectation loss.
I think it can, and I think this comes back to the discussion we had in opening about how one categorises reliance loss and as whether it's a standalone head of damage, head of loss, or whether it's a species of expectation. Damages, to give you clarity on what our pleaded case is, it's pleaded in the alternative to the loss of profits, and so the reason I raise the larger sum as to the value of the investment opportunity or development right, whatever you want to call it, is because that also sits with the sunk costs on the alternative side of the coin in terms of our pleaded case. If it's not lost profits, then the other side of the coin can be a reliance loss on the sunk costs of the 8 million, but also, as we pleaded, a restitution for wrong in terms of the investment right. And Mr. Montague-Smith in opening laughed off restitution as being a standalone cause of action and not a form of relief. And I think one only needs to read Goff more carefully to understand that restitution for wrong can be founded on a breach of contract. So it's just a different way of looking at the loss. It's looking at it from the perspective of the party that's breached, to say this is the benefit they've extracted from the breach. They're now sitting on a plot that they can do whatever it is they want with, and that has a value, and it's one that's been extracted from us.
Okay.
It's novel, but it stands up in our submission.
But it doesn't add anything to your case, does it?
It doesn't add anything in the sense that where we got to through the evidence is that this is a prime plot of land in a very prestigious part of Dubai, and all indications are that a development on it would be not just feasible but extremely profitable. So in a sense, we don't need to go there if the project possibilities are assessed with that in mind, and the claimants are compensated by the profits they would have realised, but for the DIFC's breaches.
Yes. All right. Thank you.
Thank you, my lord.
Thank you very much. Probably makes sense to take a short break now, does it, for the transcribers? Mr. Strange, did you want to make a contribution?
No, my lord, I just wanted to make sure that everyone knew I was alive and kicking and listening intently.
My lord, can I just inquire as to what happens next, in that you've obviously had my learned friends' speaking note, and the next stage, I think I'd understood that my learned friends have finished their submissions, but unless, and I may be wrong about that, but it'll be me to go next. But you haven't had my speaking note because I was waiting until I'd heard what my learned friends said, and then I was going to just take a very short period of time to update what we've been preparing and then get it over to your lordship. I mean, I can try and make a start now, but it might make more sense if I spend the next 45 minutes finalising that document, get that over to you so you have some time to read it this afternoon, this evening, and then make a fresh start on it tomorrow morning. But I'm in your hands.
It's just a question, what the most efficient use of time is, Mr. Montague-Smith?
Yes. My own view is that we've got tomorrow, and it would probably be more efficient if you saw what we have written and read it, and then I can take you through it. It's It's a fairly full speaking note, but I will speak to it.
And best guess as to when you'd get that to me?
As I say, it's in fairly advanced form. I just want to take a short period. I'd say an hour, 45 minutes to an hour.
Well, in which case that is the most efficient use of time then. We'll break now and recommence tomorrow morning then, please, or tomorrow afternoon, Dubai time.
My lord, if you want those references to the differences in costs, I can give them to you, just in case.
All right, well, it's helpful to have them, yes.
I think it's well, I'll just give you the 2018 ones, if I may. There's obviously, there's 4 different sets of them, but it's E328 and E329. That's for the approved project.
Hold on.
Sorry. Oh, I'm so sorry. Yeah. Actually, yeah. Sorry. It's E338 to E339.
Yes.
I thought I had them. Sorry, I've got it wrong. So what I'll do is I'll put it in my note. So sorry. Thank you.
All right. Tomorrow then, please. Thank you very much indeed.
Thank you, my lord.